Are we all here? Mr. Bohr, you're live, are you?
Yeah, yes. And you can hear me okay?
I can hear you fine, and I can hear the defendant's representatives. Right, are we ready to start then? Lena, is it all right to start?
Indeed.
Yes, we're ready to proceed, Your Honour.
Yeah.
There's just two administrative points, if I may.
Yes.
The first is we have just now sent a settlement, a new settlement agreement, an amended and restated settlement agreement between the claimant and Mr. Araj. The other side would not have had much time at all to look at that. I haven't even dealt with this in my claimant's closing roadmap, which we sent to the court. But I'm just flagging that up for the court. A copy has been sent to you and a copy has been sent to the defendant.
I haven't had a closing roadmap.
Ah, okay.
I'm not aware of it. I may have had one without realizing it.
Well, that was also only sent to you a very short time ago. Let me just find out who it was sent to.
The IFC registry.
It was sent to the DFC registry. I don't know how quickly that can be sent to you, or whether we can send that to you directly.
Yeah.
Lena, have you received it?
Can I please just confirm if that is the diagram that was sent to the registry, or is this referring to a different document?
No, it's not a diagram. It's a Word document, and it's called the claimant's closing roadmap.
So 15 minutes.
It's sent 15 minutes ago.
Thank you, and I will send that through.
Thank you. There's also
have you received that, Lena?
I am just checking, Your Honour, if I've received it. I've received the closing submissions and the settlement agreement, but I can't seem to find the roadmap. If I can ask the claimants to resend that, please.
That is the closing submissions, so it's the same document. Yeah.
Then yes, that's been sent.
If you could forward those to me, I'll bring them up on screen. Just while we're on this, is there anything else either party sent me which I might not have done?
Only the fact that in cross-examination yesterday, Mr. Cameron mentioned the cheque, and he said that he had a photocopy of the actual cheque, which is something we've been trying to get hold of for some time. He mentioned in cross-examination that he would give that to us subject to his lawyers. His lawyers have got back to us and they said we can see it, but they won't send us a photocopy of it. So we'd have to go to their offices, which, well, firstly, we wonder why that is. And secondly, of course, we haven't had an opportunity to do that since late yesterday evening, when we were told. It was this morning, in fact. Yeah. So we're just wondering why they can't just simply send us an email with a PDF of it. The reason why it's important, of course, is because the date of that check will tell us when, well, the argument we put is like this, that if the defendant knew of the alleged misrepresentations, the truth of them, prior to making that check, then clearly there was no reliance on them when he issued a check for the entire amount of the QNB loan. So understanding the date of that check is obviously fairly important.
Yes, well, let's just deal with that issue. Mr. Mohammad, are you able to help on this?
Yes, Your Honour. First of all, a clarification. Mr. Cameron did not accept to provide a copy of the check. That is not what he said. He said he would have to take advice from his lawyers, yeah. and I believe Mr. Bohr accepted that. So that was, with all due respect, a misstatement of what Mr. Cameron said.
To be fair, Mr. Bohr this morning mentioned having to take advice from his lawyers. Is there any reason why we shouldn't see the check?
Well, secondly, Your Honour, I have written to counsel. I wrote them at 6:34:35 this morning to say that I have seen the check and that the check bears no date. So there is no date on the check. If they wish to inspect the photocopy, they are welcome either to come to our offices, or I am happy to walk the check down to theirs. Our offices are roughly 400 meters distance apart, sir, and I could always use the steps. Now, leaving all of that aside, the relevance of the check is said to be with respect to the date on which it was communicated or shared. And in that respect, the issue date of the check, so whatever number would be or date would be on that check, would be entirely irrelevant. Now, the reluctance in providing the copy, Your Honor, is with relation to preventing other procedural claims being made in respect of that check out of context.
Meaning what?
Meaning that the photocopy could be used and taken out of context for the purposes of other actions, my lord.
But you say you tell me you've seen the check, have you?
I have, my lord. And I can assure you, my lord, that it has no date, and counsel is welcome to inspect it. And I see no reason why they would not inspect it in our offices unless there was something untoward.
Mr. Bohr, if all you're looking for is a date on the check, and Mr. Boumahab says that he's inspected it and there is no date, and you're welcome to check that by looking at it, or you or one of your colleagues is able to look at that and check that. Is that not sufficient?
We say it's somewhat irregular. I'm not going to make a big deal of this.
But Mr. Ball, we're at the day 3 of the trial.
Yes.
We don't worry about irregularity.
Exactly.
If there is substance in the objection, then of course
Yes.
I'll listen to it. I want to know whether there's any substance in your point once you've had that undertaking from Mr. Boumahab.
No, we'll inspect the
and that offer.
Yes. I heard what you said, my lord, and we will inspect the check when we can during the break. If we will try and do that.
Thank you.
Yes.
Thank you, my lord, and thank you, Mr. Bohr.
Is there any other preliminary business? Sorry, shall I just, do you want to give me about a minute and I'll just try and download your submissions?
Yes, I'm sorry for the lateness, but I thought it'd be helpful.
These things happen. I'm sure it will be helpful. So, how am I going? I've got about 6 windows open. Give me a sec.
Okay. Should we turn our cameras off and wait for you to reappear and then we'll come back?
No, I don't suppose I'll make any facial grimaces more than usual. Right, I think I have everything. It's now 1:15. Shall we reset the timetable and start now? Everything quarter of an hour later. That makes sense.
Yes, it does. Thank you.
Thank you, my lord.
Okay.
My lord, can I ask a question, please, before
Yes, of
before
course.
we engage? My lord, we received at 10:54 a.m. Dubai time. I received, I should say, at 10:54 a.m. Dubai time today. That is 6 minutes before we were required to join today's hearing. We received an email from counsel for the claimant, and that email, 10:55, pardon me, that email attaches a document referenced as a settlement agreement. This is a further settlement agreement, it would appear, my lord, dated 29 April 2025 between the claimant and Mr. Araj. Now, I don't know, my lord, how you would like to deal with that, and I can make the obvious points, but of course, we have not had any opportunity to consider this. And we would, at the very least, require that. Now, I'm not sure whether we would require it now or at the break, perhaps. But at some point, we will have to see this document. And I don't know if Mr. Boer is going to reference this document in his closing statement today. I would like to know. And if so, what he says this does.
This is a document that you've been calling for, is that right?
No, my lord. Actually, day before yesterday, day before yesterday, my lord. It's all Groundhog Day to me. But day before yesterday, my lord, you may recall that I cross-examined the claimant, Mr. ALMHEIRI, and one of the things that we spoke of towards the end of his transcript, towards the end of his examination, and which you will find towards the end of his transcript, is that Mr. ALMHEIRI had in fact transferred to the then first defendant, Mr. Araj, the company that is at the heart of our proceedings, EVL, and he would have us believe, I think, that was done in furtherance of, he said, the settlement agreement, which of course must in those circumstances predate his testimony. This one does not. And suggested, my lord, that EVL had been transferred to the first defendant for no value. You will remember I pressed him on that.
Yes.
I discussed his friends, anyway. I think you get the picture, my lord.
Yeah.
So this now is something new. This is not the document I was requesting.
I see that. Well, I think let's take it step by step. We don't know at the moment whether, well, we can guess that some use is thought to be made of this by the claimants. We haven't had an application yet to admit it in some way, nor have we had, therefore, the arguments in opposition or whatever in response to that application. Until it is sought to be introduced, I propose to disregard it. If it is sought to be introduced with an explanation and a coherent explanation, I'll make sure that you have an opportunity of dealing with it. If I allow it to be introduced, but I think let's take it. It's easy to jump several stages ahead and then get in a muddle. Let's take it step by step.
Thank you, my lord.
Okay.
Yes.
Right. I'm going to close that document for the moment. And Mr. Boer.
Yes. I'm grateful. So you had a closing roadmap. You did ask for, well, you did suggest that we could make this document fairly rough and ready, and
Yes.
we've done exactly that. So I apologise for all the typos and formatting errors, etc.
Sure.
I'll try and put them. I'm going to make some general comments about the evidence and then come on to the defences and deal with each defence in turn. So in terms of the evidence itself, let me just go through the various witnesses and make some general points. In relation to the claimant, we say that his evidence was clear and cogent. And we say that it was clear from his evidence that not a single of the alleged misrepresentations was made or confirmed by the claimant himself. There's no suggestion that the claimant intended to deceive or knew about any deceit on the defendant. So that's the claimant's evidence. On the defendant's evidence, that's Mr. Cameron's, what we say about that, and I put this as neutrally as I can, we say it lacked particularity, which isn't surprising because in fact, as we've seen in opening, the witness statements and pleadings themselves lack that particularity too. And we say that Mr. Cameron also displayed on occasion selective memory on some of the key issues, including each of the alleged representations. He was unable to explain why he never once sought written confirmation of the alleged misrepresentations. He said there was trust between the parties, and you can see on the roadmap we have a reference, but he accepted that he wasn't terribly close to the claimant. He'd never met Mr. ALMHEIRI. So we say, given that, there couldn't have been much trust. We asked
Mr. Ball,
yes.
I'm sure this is helpful. I just possibly confused. I wonder whether C is always used consistently to mean the claimant or to mean Mr. Cameron. In the first paragraph, for example, end of the third line, never said C lied to him. That C means Mr. Cameron, does it?
No, yes, that does. What I've done on my, as I told you, that there are some errors. So when the word never, from 3 lines down, that bit should be actually underneath the D bit. So I'm going to come on to that, which is why I jumped over it when I was.
I see. Okay, that's fine.
Yeah, so I think we're using it consistently. That was just in the wrong, that bit of the paragraph was in the wrong place.
Okay,
and in fact, I put a little bubble and moved it down to underneath the D.
That's helpful.
Yes.
Sorry,
I'm grateful. No, not at all. So going back to the cross-examination, Mr. Cameron said that there was trust. We say that doesn't accord with what he said about not being terribly close to the claimant and never having met Mr. ALMHEIRI. And we asked him, well, if it's so important, why were the representations not confirmed in writing, including in the agreement? And he said it never crossed his mind. And we said that's not really an answer at all. And moving on to the point that you just mentioned in terms of if you look at the paragraph above, he never said, Mr. Cameron never said that the claimant lied to him. And in fact, he said, I asked him, are you saying that the claimant tricked you? And he said, no, I'm not saying that. Although then I pushed him, I explained to him why that was important. And then he said, in this general way, well, I agree to what my lawyer said. And when we say that shows, in fact, that actually Mr. Cameron doesn't really submit, think that the claimant tried to trick him. It wasn't really the claimant, it was his complaints were about Mr. Dazi and indeed Mr. Araj, who was defendant number 1. In cross-examination, he also said that he knew about the misrepresentations by November 2017 because he referenced a meeting with Mr. Nejar in Paris at that time. And yet, surprisingly, he only raised them, these, what you say, crucial representations. He raised them only in these proceedings. And again, all this points to the fact that either there weren't representations or they weren't taken as representations. It certainly doesn't support the defendant's defense. So that's his evidence in general. There's also a witness statement from Mr. Faccinelli, a very short one, that was submitted just prior to the PTR by the defendant. We say it deals with no material issue, and that's why we didn't call Mr. Faccinelli. Mr. Cameron also wishes to rely on hearsay evidence, and we've made comments about this in our skeleton argument at paragraph 92. There's 2 pieces of hearsay evidence or hearsay evidence from two people rather. There's the Nedjar memorandum, which was Mr. Cameron was taken to yesterday, and then there's the witness statement from Mr. Araj. In terms of the hearsay, it's important to highlight, as we have done in the skeleton, that the defendant included in a statement filed by his previous lawyers that he would be calling Mr. Araj and Mr. Nedjar, along with the 11 other witnesses. In cross-examination, towards the end, Mr. Cameron gave a thorough account of why no one appears to support his case, despite him saying earlier in cross-examination that there were many, this is the word, he actually used it 4 times, meetings at which the alleged misrepresentations were made, and yet no one appears to support him. In fact, despite the explanations that Mr. Cameron gave for the first time yesterday, Mr. Cameron's lawyers gave their own explanation on the 21st of March when putting in their hearsay notice as to why no one but Mr. Cameron and Mr. Facinelli were being called. What they said in their hearsay notice is that the defendant does not intend to test the credibility of Mr. Araj or Mr. Nedjar. So there's a conflict there. In other words, they're saying that there's no issue about credibility, whereas Mr. Cameron came up with a whole load of other reasons yesterday. Now, in terms of the explanation given by Mr. Cameron's lawyers, we say that's no explanation at all. And it's also not correct, because the defendant states in his witness statement, number 3, that he doesn't agree with everything that's said by Mr. Nedjar. And indeed, I took him through Mr. Nedjar's memorandum. It's the case that he didn't agree with everything. So he would have, or should have wanted to call him and should have called him. As for Mr. Araj, the defendant said in cross-examination that he was lied to by Mr. Araj. As in, he said the same thing in his defense at paragraph 43. He says the representations were made by Mr. Araj. And in which case he should be testing, or should have tested, both these people within cross-examination. We asked, Mayor Brown asked the defendant's lawyers to call those parties. They refused. And what we say about that is that the English court, at least, has said that parties should call the witnesses on which they want to rely. I won't take you to that case, but I've given a reference there. The House of Lords, the English House of Lords, in the Polanski case, has also explained how hearsay is to be taken and regarded by the court. And what it says, you can see the last line cited here on the roadmap: the court is to be trusted to give the statement such weight as is worth in all the circumstances of this case. There's also a fair amount of case law on this. We've given an excerpt from O'Hare and Brown civil litigation. There's a reference there. And what we say is applying this to this case, in fact, almost all the considerations that the court should take into account when considering hearsay evidence appear in this case. The claim that the witnesses should have been called, the evidence that's being relied upon, the hearsay evidence isn't contemporaneous. The memorandum wasn't even produced as evidence in these proceedings. And what we heard from Mr. Cameron yesterday was that he'd met Mr. Nedjar prior to the memorandum being produced. He was sent drafts of the memorandum, and the memorandum is addressed to him. It's essentially a post facto self-justification addressed to the defendant. The evidence, we also say, was made for the purpose of collaboration. And in fact, Mr. Nedjar's evidence, at least in part, we say is hearsay itself. So we're dealing with multiple hearsay, because he gives account of things that were said to Mr. Cameron, but it's not clear at all that he was present when such things were allegedly said. So we say the court should be very cautious, very little weight, if any, to the hearsay evidence.
Mr. Moore, leave aside the question of weight. Is there any rule against multiple hearsay?
No, I think you can. I don't think there's an automatic rule. I think it's.
No,
it's a matter of...
it can be relied on for whatever it's worth.
Yes, I think that's correct.
Yeah, thank you. Yeah.
So I mean, we said what we do say there was a matter of submission, at the risk of repeating myself, we say when one takes account all the factors that I mentioned, we say very little weight, if any, should be given, regardless of the fact that the court could take into account multiple hearsay circumstances. In terms of turning then to the actual 6 defences that the defendant helpfully sets out, one sees that in a skeleton argument at paragraph 20. Let me take each one in first. So their first, and we would say primary defence, is that there has been a deceit. And the law of deceit, I've set out Article 185 in this roadmap, is when one of the 2 contracting parties deceives the other by means of trickery, which leads the other party to consent when he wouldn't or she wouldn't otherwise have done so. And so we've extracted from that various elements. Plus we've added to that certain authorities. So when what one comes out with, one needs to find a deceit by means of trickery. The deceit has to be made by the contracting parties. The party that's being deceived needs to agree to something he wouldn't have otherwise agreed to. The burden of this claim is, or this defence, is on the defendant, and the deception needs to have led to the decisive motive. I should say,
my lord, I'm sorry, Mr. Bohr. I'm terribly sorry to interrupt. But I think we just heard that 7 new authorities were added. Is that what you said, Mr. Bohr?
No, I didn't say that.
I didn't hear that.
Apologies.
I thought I had heard that new authorities had been added.
No, so I meant, sorry if I was unclear. I said in addition to we've extracted some of these elements from Article 185, but the last 2 come from authorities, and you can see the references there to those authorities which are already in the bundle.
Understand. My apologies, Mr. Bohr. Your Honour.
No, not at all. Not at all. That's fine. I was going to say, my lord, just as a point, I'm going to try and finish my time early because we have Mr. Doctor, I should say, Dr. Mahmoud Hussain, who's our UAE law specialist. And so I'm only going to deal with the UAE law points lightly, and he's going to fill in any details and indeed answer any questions on that the court may have. So turning then to the pleaded allegations, these are set out in the defence at 43, paragraph 43. And they're dealt with very shortly in the defence. Essentially, they say that Mr. Araj and Mehdi Dazi stated to Mr. Cameron, number 1, that the claimant would procure executed indemnities from Mr. Araj and Mr. Al-Mahdi, that the QMB loan would be financed by 2 equipment leases. These are all very familiar to the court, of course, and that the control and ownership of ECL and EVL would pass to Mr. Araj. So those are the only 3 allegations that have been made. In our skeleton argument, we came up with 7 points in response to this allegation, and they are still sound. And in fact, we say we've made each and every one of those good during the course of these proceedings. So dealing with each of our points in response, we say, firstly, the alleged representations, they still lack, even after the defendant has multiple opportunities to clarify what was said and by whom and the circumstances. He hasn't done so, and they remain therefore vague and indeed contradictory. And before coming on to what the substance of the allegations are, and it's very difficult to actually understand them, we say that there are very good reasons why, particularly in cases of deceit, misrepresentations need to be precise. Because the first point is that there's a world of difference between saying, I hope something will happen, and something will happen if you do Y, or I think something will happen, or the claimant promises you that something will happen, or indeed in this case, for example, of Mr. Al-Mahdi will give you a guarantee, because that would imply that it's Mr. Al-Mahdi who's promising to give the guarantee and not the claimant. And this is, yes.
Is that necessarily right? I mean, of course, they can all mean different things or amount to promises by different people. But if you take the real world where there is an underlying expectation one way or the other, that expectation could amount to a promise, even if it has to be pieced together by different things that different people say.
It's absolutely correct that We would say the mere expectation itself wouldn't be sufficient. You still need a representation of some sort. That's being made.
Just taking that expectation point, an expectation recognized by the other party to exist, and that party keeps silent about it, doesn't contradict it, could in certain circumstances amount to representation by that party.
It can, and that's the point that we would make, is that the circumstances are all important. A point that I was going to come on to is what we have here is a situation where the person, well, there's two people alleged to make the representations, Mr. Araj. Now, clearly he's not a claimant, so anything said just by him wouldn't count anyway. The only person's representation would be Mr. Dazi. The difficulty here is that Mr. Dazi is acting for the restructuring as a whole. And Mr. Cameron used, there is reference in this document to the language like we were all in this together, this is all for all our benefit. And we've said that in terms that Mr. Dazi was introduced by the claimant, and the claimant of course admits that, and he was a contact of the claimant in addition to other people. But when he was acting, for example, in relation to HSBC or Mr. Nejah in relation to HSBC, or putting together the various documents, he wasn't doing that just for the claimant. He was doing that for everybody. And there are numerous examples, and we've seen some, we'll see some more, where Mr. Cameron is engaging Mr. Dazi and Mr. Nejah as if he's representing them in some respect. Now, given that, even if in relation to specific matters, Mr. Dazi was representing the claimant, even if that is the case, it is very important to understand the statement, because only then will the court be able to judge whether the statement is being made in the general context of the restructuring or as a representation in relation to the indemnity agreement. So just to make this point good, for example, if Mr. Dazi says we're going to have a facility agreement, the QMB facility agreement, and there are going to be equipment leases in that, he's just explaining the mechanism that happens to be in the contract. I mean, we don't resolve from the QMB facility agreement, but if he's on the other hand says the claimant is promising you, Mr. Cameron, that this equipment lease will be put in place, and therefore the loans will definitely be paid this way before any indemnity is called upon, and that has a completely different look. So we agree with the comments that have just been made by Lordship in relation to the way that misrepresentations can work in circumstances. But these circumstances are unusual in the respect that I've just explained. But the second point in relation to clarity is that for the representations to be taken as being important and relied upon, one would expect the defendant, in this case, Mr. Cameron, to have very clear recollection of what specifically the representations were that were made. The other points, general points, is that these representations were never raised in pre-action correspondence. There's no record of any alleged misrepresentations prior to these proceedings. Then when we look at the pleadings themselves, the defendants pleaded these bare statements from Mr. Araj and Mehdi, but we're not told about anything about the details. And again, of course, misrepresentations can be seen from expectations, but for example, if a representation was made that Mr. Cameron would have control of the shares, that's not a complete statement. One would still need to know when Mr. Cameron was in control. And indeed, what has come out is that Mr. Cameron himself accepted in his final witness statement and accepted in cross-examination that him and Mr. Araj together would only have control. In other words, together they would have 100% of EVL ECL when the QMB loan is being repaid. And that, of course, changes the whole case because the QMB loan was never repaid. So these things are very, very important in this case. Then one looks at the witness statements, and again, one starts with the second witness statement, and one sees a lack of clarity there. And then one moves to we gave Mr. Cameron an opportunity in our request for further information to state more specifically what the alleged misrepresentations were. He didn't take the opportunity. You have references there. And then in cross-examination, Mr. Cameron came up with countless new points, which were stated for the first time. Suddenly, we've heard, again for the first time, that there were numerous meetings and phone calls and conversations. None of these have been referenced in any of the witness statements or indeed in the pleadings. Then there are different and contradictory positions. So in some respects, Mr. Araj is seen as the victim. So Mr. Araj and Mr. Cameron, it's stated in some places, they were exposed because there was no indemnity given by Mr. Al-Mahdi. And yet, Mr. Araj, as I've already mentioned at paragraph 43 of the defense, is seen as the person or one of the people making the misrepresentations. And he's referred to as a liar in the cross-examination, was referred to as a liar. And yet, strangely, again, Mr. Cameron wants to rely on Mr. Al-Araj's evidence. So he wants to have it both ways. And again, this is all very inadequate, and we say insufficient to establish a very serious claim.
Mr. Bohr, and I take the overwhelming impression you're trying to create of inconsistency, unreliability, and so on. But there is no reason why, in real life and in law, someone cannot accept what a person says on one issue, but regard him as a liar on other issues. And that sort of inconsistency is commonplace in almost every human interaction.
Well, the difficulty with this case is that what Mr. Cameron is doing that with the same issue. So take the Mr. Al-Mahdi indemnity issue. In the pleadings, Mr. Cameron is saying that Mr. Al-Mahdi, Mr. Al-Araj misrepresented that Mr. Al-Mahdi would provide an indemnity. Yeah. And yet, he's also saying in his witness statement that Mr. Al-Araj and Mr. Al-Mahdi are exposed. And indeed, Mr. Al-Araj's whole tenor of his witness statement is that he signed the agreement. He agrees that he signed the agreement, but he withheld giving it over because he knew by that time that Mr. Al-Mahdi hadn't provided a statement. And Mr. Cameron says, yes, both me and Mr. Al-Mahdi, he wants to jump on the back of that and say, both me and Mr. Al-Mahdi were misled. And yet he also said in cross-examination, Mr. Al-Araj never told him that he knew that Mr. Al-Mahdi never signed the statement and he was being misled by Mr. Al-Araj. So it's not a case of saying, well, I agree with this and I don't agree with that. It's a case of saying, I agree with him and don't agree with him on the actual same point. Mr. Al-Araj, so I will say this quickly because I've heard what you said about the specificity of representations, but it is important to point out, as I did to Mr. Cameron, that Mr. Araj suggested there was some arrangement between 4 UBOs in relation to only to the 25% interest. And of course, that doesn't go to the alleged representation, because the alleged representation is that Mr. Cameron would receive control and ownership of the entirety of UBL and ECL. So again, there are serious inconsistencies there. Then the memorandum of Mr. Najjar, we say firstly it doesn't contain anything which mentions the claimant represented to the defendants. It's actually all about Mr. Dazzy's wrongdoing and mostly about the security check. And yet the defendant said he met Mr. Najjar in Paris and input it into this memo, but there's no mention at all of the representations called lies by my then friend in opening to do with the control point or the equipment leases. Now, one would expect, and the court can certainly take this into account, that if in fact these points were taken as representations, then that would be reflected in the memorandum to some extent. The memorandum only deals with Mr. Al-Mahdi's indemnity and the security point. So those are general comments. I'm going to get more granular now. So turning to each of the alleged misrepresentations, starting with the one about Mr. Al-Mahdi, we say there's still a lack of clarity. When was the defendant told that Mr. Al-Mahdi would sign indemnity, by who, in in what circumstances. And then there's a new point arose, and we believe it's a new point. We can't see it in the pleading case of the witness statements, that Mr. Cameron says he was told that Mr. Al-Mahdi had signed the indemnity. In other words, the way it's pleaded is that he's told that an indemnity would be procured. But now he suggests that he was told at some point, again, not very clear, and Mr. Al-Mahdi had signed. So when the court asked, when your lordship asked earlier about the specificity of representations, this does make a difference, of course, whether in fact it was said that an indemnity would be procured or had been procured. And this point of had been procured is new. I won't go through all the citations that are here at page 6 of the roadmap.
Mr. Moore, can I just ask you one question about representations? And then this point you've just been talking about highlights, identifies the question really. In English law, there would be a difference between someone saying Mr. Al-Mahdi had signed the indemnity, which would be a statement of fact, and
yes,
that he would sign the indemnity, which might be taken as a promise for the future. But the only statement of fact to be implied from that would be that I have reason to believe that he will.
Right.
But does UAE law draw the same distinction between the promise and a statement of fact?
Yes, that happily is a question for Mr. Mahmoud, Dr. Mahmoud Hussain, who will answer that, no doubt, when I ask him to do so.
Okay, that's fine.
Yes.
Yeah. Okay.
Yes.
Thank you.
This is important. And of course, the pleading themselves only allege the former, that this will be procured. So in terms of other evidence relied upon, I've mentioned already Mr. Araj's statement. He has a different story about the indemnity. He said it was agreed between 4 people. Well, that's different. And indeed, given the difference, Mr. Araj should have come to give evidence, and we've spoken about that. Mr. Cameron also relies on an email, which actually, if we can bring this up at page 538. This is an email that has appeared a number of times in this last few days. It's an email that Mr. Cameron wants to rely upon to show that there was a representation that Mr. Al-Mahdi would provide an indemnity, in other words, in the future. And the point about this email, firstly, that it's dated July 2014, that's over a year, it's 13 months or so before the actual indemnity was signed by Mr. Cameron. And but more importantly, it's not an email from the claimant or even Mr. Dazi directed at Mr. Cameron on behalf of the claimant, because one can see that it starts, "Dear Khaled and Khaled." It's what it seems to be, at least from cross-examination, is a draft email that Mr. Dazi wants to send to these two individuals, the claimant and Mr. Al-Mahdi. And what he says at point 2, which is the crucial point for Mr. Cameron, he says the loan will be guaranteed by the SPV, and after the transaction, the company, and as it was suggested by Khaled Al-Mahdi, Ali or his company will guarantee the personal guarantee. And Mr. Cameron wants to say, well, this shows that there was a representation by or on behalf of the claimant that Mr. Al-Mahdi will, going forward, sign an indemnity. But in fact, if one reads the wording here, it doesn't do that at all. In fact, it contradicts Mr. Cameron's case for 2 reasons. One is because it says it was suggested by Mr. Al-Mahdi. In other words, it wasn't suggested by the claimant. It says that this purports to be a statement made in relation to something that Mr. Al-Mahdi himself was proposing, which of course makes sense because it's Mr. Al-Mahdi who would be providing a guarantee. And the second point is that it's only a suggestion. Your Lordship asked about matters of opinion. We would submit that this goes even one step prior to that. It's a mere suggestion. It's a suggestion that was made over a year before the indemnity was signed. And it's a suggestion that's made in correspondence that's outward bound. In other words, it's something that Mr. Dazzy proposes to send, not inward bound, not coming to Mr. Cameron as a representation. And one can see that specifically because if one scrolls up, Mr. Ezelddine Araj says it's okay. He's happy with the content of that email. So this email really doesn't help Mr. Cameron. There's another email at page 586, which I discussed with Mr. Cameron yesterday, which is short and somewhat difficult to decipher. It talks about an attachment, although it doesn't refer to the indemnity. One can assume that it's the attachment that follows, which is a draft indemnity agreement. And it says that everybody needs to sign. And the big question is, who is everybody? Is he saying at this point in time that everybody, all the UBOs need to sign? Well, Mr. Cameron first said when I asked him about this was, well, that this meant Mr. El Araj, and it meant him, Mr. Cameron, and it meant Mr. Almadi. But I pointed out to him that it says on the next line, the one that's highlighted in yellow, I let you transfer it to the others. In other words, Mr. Dazzy wants this indemnity signed and then transferred to the others UBOs. And says, I will send it to Ali, which Mr. Cameron suggests is Ali Ahmadi, which obviously means that others means people in addition to Mr. Al-Ahmadi. And so I put to him that really what all this is saying is once the document's been agreed and signed, can you just let everybody have a copy of it so everybody knows what's going on? Because of course this restructuring involves everybody, and it does no more than that. This of course is dated, the email sent on the 11th of May. The indemnity is only in draft form. There were changes that were made. And this is still 3 months off from when the indemnity was signed. It's certainly not a representation in any respect, and it doesn't say assist Mr. Cameron at all. And what happens next is at almost 6:07. You have this email again, which the court's seen a number of times. I took Mr. Cameron to this. There's two emails on the page. There's an email at the foot of the page, which are questions on the indemnity from Mr. Cameron, and then responses from Mr. Dazzy. And there are a number of points that come out of this which aren't helpful at all to Mr. Cameron. One of them is we see that Mr. Cameron is very careful about what he signs. He's also very careful about having everything that he possibly can in terms of concessions put in the agreement. And he's asking for things, as one can see from the very first line at page 607, which are going to help him raise a defence should he be pursued under this agreement. So the point here also is that he's trusting Mr. Dazzy with this information, that he's going to try and get out of this indemnity if he possibly can. So he wants a reference to the secured term facility agreement in there. He wants that removed. And Mr. Dazzy tries to help him out. He says it's not possible from a conversation with Cam. So another point here is what you can see happening. Firstly, as I said, Mr. Dazzy is in a sense acting as a man on the inside. That's the way I put it for Mr. Cameron. But also what's happening is on these specific questions of the indemnity, the way that it works is Mr. Cameron goes to Mr. Dazzy. Mr. Dazzy goes to the claimant, and then he comes back from the claimant and he says what the claimant will or will not accept. And that goes again to the point of particularity. We don't have any suggestion that in relation to these representations, that's what happened. For example, there's no suggestion either that Mr. Dazzy was approached and said, and the question puts him, look, I need to make sure that Mr. Al-Mahdi will be giving an indemnity as well as me and Mr. Araj. And then Mr. Dazzy goes back to the claimant, comes back and says, yes, I've spoken to him, that's the case. It's not even alleged that that's happened. And we say one would expect an email like this if indeed that did actually happen. Well, Mr. Cameron, I pulled all this to him and said, well, of course I need an indemnity from Mr. Al-Mahdi as well, because he says his reason for needing this as a representation, he says, was because Mr. Al-Mahdi was a chairman of QNB, and therefore QNB wouldn't have sued any of us under the indemnity. The claimant wouldn't have sued any of us under the indemnity because QMB would never have pursued the claimant for the loan. And our reaction to this is there's no evidence for that whatsoever. And it also makes no sense if an institution, financial institution like QMB, lends $25 million, it will want that money back. And the court doesn't need to take my word for that. QMB has pursued the claimant for that money, and indeed the claimant is paying an agreed amount back to QMB. Why also wouldn't QMB take an action which indirectly may affect a director or chairman? I mean, if it granted a loan at the behest of Mr. ALMHEIRI, which one can assume may have been the case, and he's agreed to indemnify the claimant in relation to that, then why wouldn't QMB, we would ask rhetorically, pursue the director? In fact, Mr. Cameron told us that Mr. ALMHEIRI is in jail for some irregularity. So he has been pursued, albeit in a different context. But more to the point, when someone's a director, there's no guarantee they're going to be a director or chairman forever. Mr. ALMHEIRI may have left. I mean, indeed, he's been, for example, he's in jail. And so that doesn't work. The indemnities, by their nature, are independent agreements. And the way the whole thing is set up is that each indemnifier is liable for the entire loss, which is precisely why the security check was for the full amount of the QMB loan. So Mr. Cameron, we say, would be quite naive if he really believed that had Mr. ALMHEIRI given an indemnity, somehow he would be protected. The point being that QMB wouldn't need to pursue Mr. ALMHEIRI. It could just allow the claimant to pursue the defendant. One would also have to ask, why would Mr. ALMHEIRI want to give an indemnity? Mr. Cameron himself told us, and I've given a reference here at my point 4, page 8, that everybody, all the UBOs, were going to be leaving these companies, leaving eventually him and Mr. Araj in charge. Why on earth, we would ask, would Mr. ALMHEIRI want to give an indemnity in such circumstances? In a situation, of course, where he would be greatly exposed. I mean, the reality is that the defendant has already said that he thought there was no danger from HSBC pursuing him, and we say he was wrong about that. He would, on that basis, have more reason to think that QMB wouldn't pursue anybody because there's some connection between a UBO to that entity. And that really is the end of it. We say that Mr. Cameron essentially took a business risk. So that's misrepresentation number 1. Misrepresentation number 2, we say that the defendant failed to evidence the alleged promise in relation to that. There's no reference in the pleadings to when the leases were promised to be signed. And it became apparent in cross-examination that actually Mr. Cameron didn't expect the leases to be signed when he entered into the indemnity. He didn't expect them to be signed until they were meant to be signed under the QMB facility, which was 2 months after first drawdown, which is sometime, I think, in March 2016. And in fact, that's exactly what happened. The GSS lease was signed on the 30th of May 2016, as Mr. Cameron accepts. So in relation to that lease, the lease in relation to the main company, GSS, that lease was signed under the QMB facility as intended, and that's the end of the matter. So I mean, it's very puzzling how indeed this amounts to number 1, to a misrepresentation, and number 2, how it amounts to a misrepresentation that was deceptive in any way, and number 3, how it amounts to a misrepresentation that wasn't actually fulfilled. In cross-examination, I also mentioned to Mr. Cameron that in his witness statement, he actually says that he only expected the loan to be funded by one or both equipment leases. So, but in the defense, he's complaining about there not being an Odyssey lease as well. But one can see from his witness statement that actually he didn't necessarily expect that, which of course also makes sense because the Odyssey doesn't feature in any of the transaction documents at all. It's really the GSS lease, and there's good reason for that, because the structure of this whole transaction is that 24 million went to EVL, which then went to GSS. Sorry, the 25 million went to EVL, and then 24 went to GSS, and 1 went to Odyssey. So the Odyssey and the Odyssey lease is not material, which in this context, which is why there's no written agreement. And in any event, an Odyssey lease was circulated, but wasn't signed because events intervened and there was a default. More to the point, and this again was taken up with Mr. Cameron in cross-examination, Mr. Cameron himself was involved, and we would say heavily involved, in the management of GSS and Odyssey. The general manager reported to him. That's his own evidence and his witness statement evidence. And of course, he had to accept that in cross-examination. He also accepted that the claimant wasn't responsible on GSS and for GSS's and Odyssey's failure to implement the lease agreements. In fact, we would say that that was something that Mr. Cameron had more involvement in, had more influence over than the claimant. So again, this is not a representation. It's certainly not a misrepresentation. It's not a deceptive misrepresentation. It's not one that's not being fulfilled. It's a matter of opinion indeed, and it's one over which Mr. Cameron himself had a great deal of control. And in relation to the minimization of exposure that Mr. Cameron suggests, we submit that actually Mr. Cameron should have understood that the indemnity agreement gives him liability, imposes upon him liability for the entire QMB loan. And indeed, he signed a check for the entirety of the $92 million loan. So that's misrepresentation number 2. And misrepresentation number 3 is the share issue, which I've already mentioned. Again, no particularity in pleadings. And then the allegations on this are a moving feast. In his second witness statement, the earlier witness statement, he says that he was promised by Mr. Dazi and Mr. Araj to have 25% given to 4 remaining UBOs, which includes the claimant, but which isn't what his pleaded case is, because this doesn't involve controlling interest. It also, he doesn't state in the witness statement when he was meant to receive the 25%. Only in cross-examination did he say, oh, I was meant to have this by the time that the HSBC loans were recovered. There's no evidence to that. There's no rationale for that either, because what he wants is shares in EVL and ECL, which are the entities, not the entities that were loaned money by HSBC, but these SPVs. And again, we said the court should ignore this new evidence. And the fact is, the court should just say this 25%, whatever this is, certainly isn't a representation, is extremely unclear. And then, but more than that, the story changed, as I mentioned. In the third witness statement, the defendant said, well, in fact, we were meant to get 25%. Again, he doesn't say when. And then later, we were meant to get 50 when the QMB loan is repaid. And as I say, our answer to that is, well, even if that was a representation, it was one of opinion again. But even with that, on your own evidence, we would say, Mr. Cameron, the control was only to be given to you when the QMB loan was to be repaid, and it never was repaid. And in any event, the defendant later, January 2016, so a long time after the indemnity agreement, when Mr. Cameron must have known that he never had the shares or any shares, he gave a check for 92 million AED. But more than that, he never on his evidence got that check back. It doesn't seem like he attempted to either. He said it's just out there. I don't know who's got it. So on that basis, he's essentially confirming the obligations of the indemnity, despite knowing, of course, that he doesn't have the shares that he says he was meant to get. So again, it's not a representation, and it's not one that been breached in any event, even on the claimant's defendant's own position. I've taken the court just in terms of the other documents that I said to support this. I'm going to take this quickly because I'm running out of time. But there's an email from the 3rd of September, which is pleaded as a matter which supports this. But actually, one could see from the cross-examination that it deals with a completely different matter, as Mr. Cameron accepted. And I don't think I need to take you to the other points on this, including indeed the apparent motivation in relation to that. So just moving to the point 2 on the deceit claim, we say that there's no statements being made by the claimant. What in fact is being relied upon is a statement made by Mr. Dazzy. And we say the problem with that is on page 12 now of the roadmap is that Mr. Cameron hasn't engaged with UAE law on agency, but as explained in this second bullet point, page 12, the fact is that Mr. Dazzy wasn't just acting for the claimant, and certainly not all the time. And therefore that puts a particular onus on Mr. Cameron to check, at least as a matter of UAE law, and Dr. Hussain can explain this, what the true position is in terms of Mr. Dazzy's agency, if Mr. Dazzy is making statements which want to be relied upon later. And this is particularly true given the existence of the entire agreement clause in the indemnity agreement. I'm going to leave the remainder of UAE law to be dealt with by Dr. Hussain. Our point 3 is this is not just a case of misrepresentation, it's a case of deceit, which of course is a very high burden. We've set out in brief bullet point form on page 13 what UAE law says about that, and we say there was no evidence for the claimant's dishonesty or that the claimant knew of any dishonesty. I'm not even sure that was ever even put to him. Then
does dishonesty include recklessness?
Again, it's a question for Dr. Hussain. I'll note it down.
Yeah. Okay.
I mean, we would submit that even if that is the case, and I simply don't know, the claimant couldn't have been reckless if he didn't know what Mr. Dazzy was saying to Mr. Cameron. So assuming that this was a very clear case of an agent, and everybody knew that Mr. Dazzy was acting as agent, well, unless the claimant knew what Mr. Dazzy was saying, and there's no evidence for that whatsoever, then we'd say it wouldn't be reckless in any event. Point 4, I can take very quickly, because this goes back to points that I've already made, and I've headed it innocent explanations. But the point essentially is, one can see how there is an element, a scintilla of truth about what Mr. Cameron says. But the reality is like this. Mr. Al-Mahdi, it may have been suggested by Mr. Al-Mahdi himself, rather than the claimant we saw in that email, that he would give an indemnity agreement back a year or so before the actual guarantee was signed. But that never came to fruition. And that is essentially what Mr. Cameron is turning into a representation. Then representation number 2, the equivalent of leases. Of course, there is some truth there because the GSS lease is referenced in the QMB facility agreement, and it was to be signed after the first drawdown, and indeed it was signed after the first drawdown. But as Mr. Cameron accepts, GSS never paid a cent for it. And he, of course, was someone responsible for the general manager, so partly responsible for that. And misrepresentation 3, in terms of control, it is correct and accepted that UBOs didn't want any further involvement in the business, apart from the 2 associates, Mr. Araj and Mr. Cameron, who had business interests together, as Mr. Cameron accepted yesterday. They wanted to take control of the entities, and therefore the expectation would be that once everyone withdrew from this company, which had huge debts and depreciating assets, once they withdrew, then that company would be available to these 2 individuals. But that would only be, of course, when the QNB loan had been repaid, as Mr. Cameron himself accepts. And that's the reality. But that has been turned before this court into a deceitful misrepresentation. And we say it just simply doesn't work. Point 5 is the entire agreement clause. Your Lordship asked me in opening to find cases of English law by way of comparison, and I have done so. The position, it seems to be, as your Lordship noted, there are mixed messages in relation to entire agreement clause and general representations. Certainly, if this was a case of fraud, which we say is very far from, then the entire agreement clause would not help. But we say it's a very high hurdle for the court to find fraud, and certainly no basis in this case. However, what the English cases do say is that no reliance clauses, they can exclude reliance on representations. And indeed, what we have here is an entire agreement provision, which is the first part of the clause 17, but we also have a no reliance clause, which is the second part of clause 17, which says in terms, you can see this on paragraph 2, where it's page 14, you can see neither party has relied upon any statement representation except as expressly set out in this agreement. And again, so the point number 1 is that does do the deed of excluding representation as non-fraudulent, at least. But the second point is what I mentioned before, that the very existence of this clause ought to have put Mr. Cameron on notice that in fact he should be quite careful as to what is being said by who and when, and recording this if he wants to rely on anything else. There's also DAFC law, which I've cited, which refers to Article 30 of the contract law, but I won't take you to that. You'll be able to read that in your own time.
Is that
relevant?
Is DAFC law relevant or only by comparison?
No, it's neither English law or indeed DAFC law is relevant to the issue. This simply responds to a point that you raised earlier.
Yeah, that's fine. Yeah. So you're citing that as another comparator.
It's just a comparator, yes.
Yeah, thank you.
Yes. Yeah. I'm going to move on to reliance because again, I'm just watching the clock. We say that they can't, as I mentioned before, it's very difficult to see how they can be reliant, but it's not even clear to Mr. Cameron what's being promised, by who, when, how. We say how can there be reliance when one hands over a check to 92 million AUD? We would say in the knowledge of at least some of the representations. In relation to the equipment leases, in cross-examination, Mr. Cameron honestly said, equipment leases are secondary to me. And he blamed Mr. Araj for the issues in relation to that. It seemed, at least from the transcript, and he seems to put most stress on the Mr. Al-Mahdi indemnity. And we made points about that already. And then we say, well, the real motivation is quite clear. Mr. Cameron is a very astute and extremely eloquent business person who is prepared to take risks. And indeed, if it would have come off, he may have ended up in a good position in business with Mr. Araj. It seems to be, from what he said at the outset of his evidence, that his business with Mr. Araj came to an end. And this indeed is just another one of those. It didn't turn out perhaps the way he expected, but that was the risk he took, and that was his real motivation. We also say 7 is the loss of a right, and that really is reliant on the checkpoint again. I'm not going to overstate this because as I said in the opening, if we succeed on any one of these points, then Mr. Cameron cannot succeed on his primary case of deceit. Moving then to his second defence, mistake. I can take this shortly because it wasn't really dealt with in great detail in opening by my learned friends. But mistakes certainly, we would say, would be covered by the entire agreement clause, number 1. Number 2, for the mistake to actually bite, and for that to be a proper defence, the claimant would have to know that there'd been a mistake. And again, absolutely no evidence to that. Thirdly, we say there were no representations and therefore no mistakes anyway. Dr. Hussain would explain the burden of the UAE law in relation to mistake. It's a high burden in relation to commercial cases. And we say, actually, the mistakes are immaterial, or else they would have actually formed part of the contract. So moving then, that's the second point of defence. The third point of defence is discharge. The other side say there's been a discharge because there's been a settlement with Mr. Araj. I'm not going to address your lordship on the settlement agreement because I I've only just seen a signed copy myself, as I mentioned at the outset, and I understand that the other side will need to take instructions. But even going on the first settlement agreement, which is now
sorry, can I just be clear on this? Although you sent or you've put in a new settlement agreement, you're not relying on it in any way.
Well, okay, so thank you for raising this expressly. We would like to rely on it. You mentioned that with a no application, so we're going to make that application.
Yeah, I'm not worried about the paper application. What I'm looking at is the substance. You are seeking to rely on it.
We would rely on it.
For what purpose? And why it came so late?
Yes. Okay, so I'll take this point in stages. There was a prior settlement agreement with Mr. Araj, which the court has and has seen. That was breached by Mr. Araj. He did not make payments under it, and then DIAC proceedings were commenced. Mr. Araj was ordered to pay his share of the DIAC proceedings. He did not do so. But by that time, the parties were in further settlement discussions. And so what the claimant did was continue those settlement discussions without paying Mr. Araj's share of the DIAC proceedings. The other side would like to rely on this by saying somehow this settlement agreement discharged the debt. Perhaps it's hard for us actually to understand how their case on discharge is put, but it looks like they're saying it's a cross between mitigation and the fact that actually we've given away, they say, the GSS assets to Mr. Araj without consideration. Now, what the claimant said is that, yes, he transferred assets that he was holding security to Mr. Araj, pending the settlement agreement terms being agreed. So the other side have tried to capitalize on this during these proceedings quite heavily, for obvious reason we will submit, because the other parts of the cases are quite weak. So what they've said is there's an abuse of the security at this discharge point. Having heard how the other side put their case in opening, the claimant has clearly been inspired to let me put this in colloquial terms, get his act together, along perhaps with Araj. And the two of them have clarified the position and created a new settlement agreement. Now, what this said, I can address you on this now, my lord, we can deal with the application later. But if I do now, I can do it in 1 minute.
Mr. Ball, there's no point making submissions on a document which may or may not be allowed to be introduced.
Yes.
At the moment, I don't see that this new settlement agreement contains evidence which is in play. We've had the witness. It came too late for the witness to be cross-examined on it. It is a document which you seek to introduce, but I have at the moment, no basis for making a decision in your favour on that.
No. Madam, may I suggest that we make the application? The only point we can take from what I'm saying now is we would like to rely on it because it goes to points that it may be just points of prejudice the other side are making, but it deals with those points head on. And so we'd like to make the application.
So it amounts in effect to further evidence from the claimant.
It does, but my lord, I would say this, that it actually assists Mr. Cameron. And the reason for that
that's for him to judge.
Yes. But I'm not going to say more about it because I've heard what you said about it not being before the court right now. We would make our application. We would agree with your lordship that the truth is it shouldn't actually materially impact the decision whatsoever. And the reason for that is
I didn't say that. You say you agree with me on that. I didn't say that at all. I'm keeping entirely neutral on this.
Okay. So, madam, let me clarify that.
I think the best thing is let's not get diverted. So I know I asked you about it, but I think the best thing is let you finish your submissions. Let you and the other side discuss. We have a half-hour break after submissions. Deal with it either at the end of that half-hour break or at the end of all submissions.
Yes. I'm grateful for that. And in that case, I'm not going to deal with defence 3 for now. We say it's a red herring in any event. You have the skeleton on that for now, and we'll park this and I'll move on to time bar. Time bomb.
Is your civil lawyer going to tell me about the principles of discharge? He'll do that, will he?
I hope so. I mean, he was going to focus on the time bomb issue, but I hope he'll get to that too.
Because there is, I mean, again, there's comparators in English law. I seem to remember from my early days at the bar that if you release one person without a reservation, you release everyone.
That is correct. That's to do with joint and several liability. So if you have joint tortfeasors and you settle a tort with one, then unless you reserve your right generally in relation to the other one, then it can be taken in certain circumstances you settle with both. This is not that case. And
yes,
even under English law would say it wouldn't be the case, because you have an indemnity where the indemnifier is a primary obliger, obliged for the entire debt, plus of course you have the check for the entire debt. So it's not a case of joint and several liability. Which is the point I made in opening. There's not one document where two people are agreeing between themselves to share liability. In fact, the concept and UAE law is called solidarity, and there's a citation in the skeleton argument, and Dr. Hussain can speak to that.
Yeah, thank you.
Defense number 4 is the time bar point. We say this point again does not assist Mr. Cameron. We have 6 main points. Mr. Dr. Hussain can speak to those in the time allotted. I'm going to just give you those points on a very, very headline basis. We say, firstly, this isn't a guarantee. And Article 1092, which has that time bar, falls into terms of guarantees. And then, again, the main reason is it's a primary obligation. And I've spelt this out in this roadmap. But we say number 2, even if it is a guarantee, there is the most recent statement of UAE law on this is the commercial appeal number 30 of 2025, so very recent. And that says that it doesn't apply to commercial cases. Now, the other side say, well, there's lots of cases prior to this. Well, we say that's not the most recent statement. Third point is that it only applies to a situation where you have a tripartite agreement. So you have an agreement where the lender has a guarantee as well as a right against the person who lent money to borrow. And therefore, that's when it applies. That's not this situation. Here you have a completely independent indemnity unrelated to the loan itself. We also say it's not correct, the point that was put to you in opening, where the commercial code doesn't deal with matters, then automatically the civil code applies, and that would therefore lead to the time bar creeping in. We say that principle deals with overriding principles such as good faith. We also say if one looks at the agreement itself, and this point was accepted by the defendant counsel, that actually you can exclude this kind of language. In other words, you can exclude the time bar more specifically. And we say the indemnity does that because there's numerous references to these ongoing obligations, including the definition of default itself, which is at 1.2d of the indemnity agreement. It's a continuing obligation. And in any event, we say there's been a waiver because there's no attempt to recover this check. So that's that. Point 5. The liability only for the third. Well, we say that's not a good point to put. We'll deal with that very shortly. There's a court settlement agreement under which the claimant is paying. That is a liability that needs to be covered by Mr. Cameron. Duty to mitigate, again, I can take this very short. What's been said to us is that because we haven't pursued Mr. Araj, we've not mitigated properly. And we say that just doesn't work, because that would mean if you have 2, 3, 4, 5 indemnifiers, each one of them could say you've not mitigated because you haven't pursued the other 4 or 5 indemnifiers. And that doesn't work. It leads to an infinite loop. And in relation to a loan agreement, it's hard to see how you can mitigate in any event, although we say we have, because we've got QMB to reduce the loan amount that it's seeking. So we have actually mitigated, again, to Mr. Cameron's advantage. And again, we will say, following our application, that given the settlement, we hopefully have saved Mr. Cameron some more money, but that's for the other side to consider. I don't have anything more to say, so if I may hand over to Dr. Hussain.
Yes, of course. Is Dr. Hussain in the room?
He's not with me physically, he's nearby there, and I believe he can.
Yes, my lord. Yes, my lord, I'm here with you.
Hello, Dr. Hussain. Welcome.
Hi. Thank you very much, my lord.
What are you going to tell me?
I'm actually, I think, first of all, Your Honor, it's my pleasure to be with this court. My name is Dr. Mahmoud Hussain. I'm appearing for the claimant, KHALED ALMHEIRI, alongside my late colleague and friend, Mr. Harris Bor from 20 Essex. Before turning to the specific defense raised by defendant over the last couple of days, I believe it would be more helpful for the court if I first briefly outline the fundamental principle governing how contracts are treated under UAE law. In particular, the distinction between nominated and non-nominated contract, as this is the central to understanding the legal character and enforceability of indemnity which is at the heart of this dispute. The UAE law and its main source, Sharia law or Islamic law, distinguish between two main types of contract. First type is nominated contract. These are the contracts that the law explicitly identify and regulate with a specific set of rules and provision. Example, my lord, include contract of sale, contract of lease, partnership, suretyship, guarantee contract. All of that has a chapter in civil law where it's explained certain term and condition of that contract. Now, the second type of the contract is non-nominated contract. These are the agreements that do not fall into one of the specifically regulated category. They are valid and enforceable, but are governed by general rules of the contract formation and obligation found primarily in Article 124 to 275 of Civil Code, Bundle K 41, page 2865 to 2891. So, Your Honor, we submit that the indemnity agreement are non-nominated contract, and as such, its interpretation, enforcement are governed by the core principle that form the basis of UAE contract. So, the UAE law doesn't speak about indemnity, so it would be treated as non-nominated contract. The principle has been clearly established, for example, in UAE Federal Court Supreme Court Judgment number 687 of 2021, which is in bundle K45 for the reference, confirmed that where contract is not expressly regulated by statute, it must be governed by general provision of civil code, applied in manner consistent with the contract's specific nature. This ensures the party mutual intention are respected while maintaining flexibility and fairness. So this is the wording of the UAE's Federal Supreme Court. Means a new contract, party can create new contract, which is non-nominated. They have the right to do it. It's a flexibility of the commercial affairs, and it's required by the law. However, what we apply on those type of the contract, the general principle of the law. The core principle that the Supreme Court stated that should be applied, freedom of contract, means autonomy of the parties, in K41, page 2865 to 2891. Another principle, good faith, husn al-niyyah, contract must be performed in accordance with their term and in a manner consistent with the principle of good faith. As well, pacta santa servanda, agreement must be kept. So basically, those are the main principles should be applied on the agreement. Now, one example to illustrate the situation is rent to own. 20 years ago, when Islamic financial institution created new kind of banking system or contract instead of the conventional mortgage, which was rent to own. So it was new, invented by the bank. When it came to the court, the court enforced such contract, although they were not mentioned in the statute. So the rent-own model was initially developed by Islamic Bank, an institution, as an innovative solution to overcome the certain Sharia prohibited associated with the conventional mortgage, particularly those involved where it are deemed non-compliance with Islamic principle. As such, these arrangements operated as a non-nominated contract governed solely by general principle of contract law, including party autonomy and good faith. And then after that, the legislator recognized that this is very important, started to shift it from non-nominated to nominated contracts. Your Excellency, the development underscored the fundamental principle of UAE law. Until particular type of contract expressly regulated by legislator, it retained its status as non-nominated contract, governed by the general principle of law and fully enforceable. For example, Dubai Court of Appeal Judgment 270 of 2010, K43, dated 13 October 2010, stated that the principle of financial leasing was introduced. It is form of partnership between owner and buyer. It continued, which ultimately resulted to a fair one. So the court recognized a new form of the contract. The law or the court didn't try to say it's a lease and apply the lease. It didn't try to say it's a sale, but it said it's a new type of the contract. Therefore, we have to apply the general principle of the law. Therefore, the indemnity agreement between the claimant and defendant is precisely such contract, non-nominated. It's not subject to any specific chapter of provision of law, unlike kafala, suretyship, which is treated as a nominated contract. The agreement creates direct, primary, and bipartite obligation between indemnifier and indemnity. According to that, the indemnity agreement must be interpreted and enforced with the general principles of UAE contract law, the express term agreed by the party, the overarching duty of good faith, and the foundation principle of freedom of contract. This is not the case of guarantee kafala, and thus the agreement falls outside the narrow and exceptional category of nominated contract, in which specific rules such as 6-month limitation period under Article 1092 of the Civil Code will not apply. With this foundation, and another point, my lord, is that the time bar, if I may, Your Honor, the defendant's secondary defense, namely alleged time bar under Article 1092 in Civil Code under Bundle I-7, which we address from paragraph 97 onward of the claimant skeleton argument. Article 109, if debt is due, the creditor must claim for within 6 months from the date on which it fell due. Otherwise, the surety shall be deemed to have been discharged. The defendant contended incorrectly that the claimant claim under indemnity is a time bar because it was not brought within 6 months of the debt alleged falling under the Q&B loan. Your Honor, the agreement is a fundamentally misconceived or several compelling reasons, which I set before you today in this submission. First, I outlined the overview beginning of my submission. The starting point for the argument must be correct legal characteristic of indemnity agreement. So indemnity agreement is separate than kafala or guarantee agreement. So basically this article will not be applied because it's a non-nominated, so the general principle will be applied. But however, for the sake of the argument, the agreement creates direct, primary, bipartite obligation from the defendant to the claimant, Article 1092. However, applies specifically and exclusively to kafala. Indemnity, like other non-nominated contract under UAE law, governed by general contract principles. So basically, it's a general principle of civil law should be applied on indemnity, not a specific article taking from, for example, kafala, which is a guarantee. My Lord, I just wanted to mention the reason for Article 1092 can be explained clearly if we go to a commentary of civil law, which is the official document issued by UAE government to explain what does this article means. If we go to Article 1092, it is to plead the debt become due. The creditor must claim it within 6 months from the date. Otherwise, the guarantor shall be considered released from the guarantee. The purpose of this provision is to avoid the unreasonability situation in which the guarantee remain in effect with all its obligation on the guarantor, while the creditor is negligent in claiming his debt. So basically, this explanation of this article by the commentary of civil law, it's under bundle K46, explain to us the situation is a 3 parties. There is a creditor who's a negligent, not claiming his debt, and there is a guarantor, which is completely the operation and mechanism of this contract is completely different than the mechanism and how operate indemnity, because it's a primary obligation there is primary obligation. Here is a secondary obligation is the debtor or guarantor. So basically it's fair. Not only that, the commentary of civil law state more. Upon setting the debt, he has the right of recourse against debtor. The creditor must hand over the guarantor all documents necessary for existing his right. Furthermore, if the debt is secured by another form of real security, the creditor must transfer it to guarantor if it's movable or transfer his right to it. If the debt becomes due and the creditor does not demand payment, the guarantor has the right to serve a notice to the creditor requiring him to take a legal action. Otherwise, the guarantor shall be released from the guarantee. The memorandum clarified that Article 1092, 6 months, the time limit for creditor to claim against the surety is specifically designed, and I quote, underlying principle to avoid unreasonable situation in which guarantee remain in effect while the creditor is a negligent in claiming his debt. It explained that this provision, along with Article 1091, conceding a surety right of recourse after payment, stems from established Islamic jurisprudence principles, such as the idea whatever is necessary to fulfill an obligation become obligatory. The memorandum further highlights the dynamic in true suretyship. If the debt is due and the creditor failed to act, the surety has the right to demand the creditor to take a legal action, which is completely operation different than indemnity. And this is, I think, my colleague are telling me the time has passed, I think, Mr. Bohr. Do you want me to continue or just stop?
No, carry on, please.
Okay.
Hang on a second. Could you wait a moment? Mr. Bohr, I'm not sure what timing, according to my program, the time stops at about 9:45 UK time, which is another 8 minutes.
Yes.
Is that what you had in mind?
I think so, yes. We had a little bit of administrative issues to deal with, but I think that's correct.
Well, if you would like to carry on for another 8 or 10 minutes, please feel free, Dr. Hussain.
Okay, thank you very much, my lord. To sum up, Your Honor, the very explanation provided by the legislator underscore that Article 1092 in Bundle I-7 is tailored to specifically tripartite relation of kafala. You need to have a creditor, you need to have as well the debtor, and you have the guarantor. So 3 elements. And the explanation in memorandum, which is issued by Ministry of Justice, explain how this article operates. And that's why always, as a civil lawyer, I have to go to the article, read as well the explanatory memorandum in order for me to understand what is the legislative intention behind this article. It's protecting the secondary guarantor whose liability is contingent upon separate principle of debtor from the consequence of creditor inaction. inaction. The rationale I submit had no relevance to direct bilateral obligation created by the indemnity agreement in this case. The Dubai Court of Cassation in recent judgment, Commercial Appeal number 30 of 2025 in bundle I-13, has confirmed that the principle of 6-month time limit under Article 1092 of the Civil Code does not apply to commercial suretyship. So basically, the first argument I argued that we have to put indemnity in a right place, which is a contract is not recognized as a nominated agreement, but it could fall with the nominated agreements, which means that we have to apply general principle. We cannot squeeze this contract to another type of the contracts. The second argument I tried to argue, I went to the Article 1092 and I explained in the memorandum, which is issued, or explanatory memorandum of Civil Code issued by Ministry of Justice, that the operation of this article is a completely different and is suitable for guarantee, not for indemnity. So therefore, it is not a place for us to apply. Now, I'm arguing for the sake of argument, saying if we say, for example, this article could apply, still the recent submission of us I-13, the court confirmed if the relationship and suretyship is a commercial transaction, then it should not be applied 6-month parameter. Probably this is the new trend with the Cassation Court after the issuance of new commercial code, which came into place in 2022. So underlying Q&B loan is a commercial, so therefore the transaction is commercial. And the two parties, the claimant and respondent, are as well are traders. So basically they are commercial. So this article would be excluded under this judgment actually. The older case cited by the respondent are outdated and not suitable for the fact of the case. What I believe, the parties acted commercially, and Article 70 of Commercial Code of Transaction has to be applied. Bundle 1, I-1, 18. I think I finished the time bar. I leave it to Mr. Bor if you want me to continue or stop here.
If you've said everything you need to say, then
yeah, I think I finished the time bar.
If there's any other points, Mr. Ezelddine?
No, I think I finished this part. I think I leave it to you now. Maybe later on we can address any other question as asked by my lord.
Well, I think the way we do this hearing, really, the submissions by the side for whom you are acting, by the claimant, now is the time. Can I ask you something about deceit in UAE law? Yes,
my lord.
In the UK and in the DIFC, where I'm more familiar, there is a distinction drawn between representations of fact, which can amount to deceit, and representations of opinion or promises for the future, which are treated differently. Is the same distinction drawn in UAE law?
I think it's if we have to divide the statement of the fact, and the UAE statement of fact is considered representation that can give rise to the legal consequence if it is untrue and had introduced other party into the contract. This may lead to claim of misrepresentation, at least Article 185, and mistake, Article 185 and 193. But the burden of proof is on the first party who is claiming. Regarding the promise, my lord, I need to go back to UAE law, and I don't have the right answer. I can send it in the closing submissions.
Well, I think this is the closing submissions. We can have a discussion at the end of the case, but really,
I think end of the day.
Yeah. Okay, that's helpful. The only other thing, I don't know whether you've been listening to Mr. Bohr's arguments about the entire agreement clause.
I didn't hear it actually.
About the entire agreement. There's a clause in the contract which says this is the whole agreement between the parties, and it goes on to say they've not relied upon any representations made by anyone else in entering into the agreement. Does UAE law have any particular approach to that sort of contract, that sort of clause in a contract?
I think, Your Excellency, as it's a term of contract and it does not violate public policy, it will be enforceable under UAE law, because applying general principle of the law of UAE, for example, good faith and pacta servanda, it will be enforceable, the article, because unless it's violate public policy. In my opinion, humble opinion, there is no anything is in this article actually violate public policy. Applying this principle, which I spoke about UAE contract law, it does not violate the public policy. Therefore, it does not, it will be enforceable by the courts.
Yes, I see. That's very helpful. Thank you. Well, Dr. Hussain, I have no, thank you very much for your help. I have no further questions at the moment. Thank you very much. Thank you, Mr.
Thank you
Bohr.
very much, my lord.
That takes us to the end of your submissions, your closing submissions at this stage, Mr. Bohr. Is that right?
It does.
Thank you very much.
Thank you.
I think the next stage is, according to the timetable, there's a half-hour break. Is that, are we proceeding along those lines?
Yes, my lord, that's okay with you and the inside.
Yes, Mr. Mohammad, is that your understanding? We have half an hour break now, and then you have an hour and a half to make your submissions.
Yes, Your Honor.
If you want to try and discuss this matter of this settlement agreement, I don't want to take up time now, but if you want to discuss it, and if there remains an outstanding issue between you, I'll have to resolve it at the end of submissions.
Yes, ma'am.
Understood.
Right. We'll resume now then at 10:15 UK time, 1:15 UAE time. Thank you very much.
Thank you.
Right, are we ready to go?
Ready to go, yes, Your Honor. Just one second, just waiting for my colleague. Just a point of housekeeping, really. Just this morning, I've noticed that there were, I think, 8 new authorities uploaded to the bundle by the claimants. I haven't had a chance to.
I haven't seen those.
It's at K42 through to K49.
I'll find them in due course, but what do you want to say about them?
Just that I haven't had a chance to read them, and 2 of them were referred to by Dr. Hussain.
Right.
So if there is something that comes of them, then we would, of course, appreciate the opportunity to respond to that.
Yes, well, what we can do is have a discussion at the end about whether anyone wants time to put in something brief in writing on points that haven't been covered.
Yes. Okay.
Yep. Very well.
All right. I think my colleague is there now. Good to go.
Which one of you is speaking?
I will be speaking. I'll have the honor of that.
Yes. Well, there we are.
Okay. Just four points to pick up on what my learned friend said in his closing. The first point is with respect to hearsay evidence. And the point was made that we are seeking to rely on 2 statements or 2 documents. One is a witness statement of Mr. Araj, and the other is a memo from Mr. Nejjar. There are actually 3 documents that we're seeking to rely on, and they're referenced in the hearsay notice, which is at D197. So in addition to those 2 documents, there is, of course, also the witness statement of Mr. Nejjar. my learned friend didn't refer to that one. The second point that was made in closing was with what reference to what Mr. Cameron is said to have said during his cross-examination. And the allegation was made that he has admitted that no one supports his case. Well, that's not what he said. He went through the different witnesses and he explained exactly why those witnesses are not before the court. So with Mr. Mohammad Kirknawi, for example, he explained that he was lost in Syria, for want of a better word. And then for Mr. Herman, he, for example, said that Mr. Herman had nothing else to add. And with reference to Mr. Shrikant, he said that he had been, quote, intimidated by Mr. ALMHEIRI. And that the transcript will reflect that in Mr. Cameron's cross-examination.
Can you give me I remember it, but can you give me a day, a time or a page number of the transcript, roughly where he dealt with that?
Not
It-
off
don't
the
worry,
yeah,
don't
not
worry,
off the top of my
don't-
head. I'll struggle with that.
No,
It's
fine.
towards
No problem.
it is, my lord, if I can be of any help, it is towards the very end of the transcript. Towards the very end of the transcript, my lord. I believe it is at page, bear with me. Well, the key word is that you would be looking for, Your Honor, is Lester, L-E-S-T-E-R.
Yeah.
And that's all I can say to that.
That
108, 108, my lord, 108, page 108.
Right.
Yeah. the
Thank you very
reference
much.
that-
Yeah, thank you.
My lord, just a point of correction. I don't believe I did say that he admitted that they wouldn't support his case. I did put that question to him. I was suggesting that his evidence was new. So I just wanted to clarify that point.
Right.
Just another point is, again, in the closing, this was with respect to the hearsay and the fact that Mr. Cameron didn't call Mr. Nejar, Mr. El Araj. We addressed that in opening. I don't propose to go through that again. Of course, that's hearsay, and we follow the correct procedure under that, under the DIFC court rules. We explained why we're not calling those witnesses, and it was then open to Mr. ALMHEIRI to call the witnesses, and in the event he did not, instead he gave another witness statement. The final point, just in terms of my learned friend said in his closing, I believe there was a reference to a $92 million check. I think the reference there would be a 92 million dirham check. So that's just a correction there.
Yeah.
So I'll move on to the closing. So in the opening we set out the facts of the case and we explained the significance of those facts to the circumstances of this case. I don't want to walk through that again. I think there was enough storytelling in the opening, but I just want to highlight four key points from that. And the first is that prior to the restructuring, Mr. Cameron had the benefit of 9 guarantors, and we set out who those guarantors were. And those guarantors included 2 VIPs, Mr. Imadi and Sheikh Al-Thani.
Yep.
In addition to those 9 guarantors, he also had $109 million in assets. So the net effect was that his exposure was no more than 1.7 million. And that's no more than Mr. Facinelli's exposure, who gave a witness statement in these proceedings and whose evidence was unchallenged. That's the first point, looking at the before position. The second point is with respect to HSBC and the thread of HSBC sort of hanging over Mr. Cameron's and the other UBO's head. There was no indication that HSBC was going to do anything, nor did they do anything. And the only thing, the only document on record is a demand notice that was sent to GSS in February 2013. That's a D22, page 492. But there's no evidence that they took any steps beyond that, so they didn't pursue the notice. And in fact, what happened is that the debt was then restructured, as one would reasonably expect, given Mr. Imadi, the then Minister of Finance of Qatar, and Sheikh Al-Thani, who's a member of the House of Al-Thani, the ruling family of Qatar. What we also have is Mr. Facinelli's unchallenged evidence on that point, saying he never heard from HSBC, and that he wasn't told anything about any restructuring, and that the whole thing caught him entirely by surprise many years later. Nor, he says, did he even know who Mehdi Dazi was, someone that Mr. Almheiri claims was engaged by all of the UBOs, which would of course include Mr. Facinelli. And a copy of his witness statement is in section D of the bundle, not in section C, and that's at D1461530, and the relevant reference to where he says that in paragraph 17 to 20. So the third point is that the only person who really had anything to lose in all this was the VIP. That's Qatar's then Minister of Finance, Mr. Al-Emadi. He was the one who wanted to avoid a public fallout with HSBC at all costs. So what does Mr. Al-Emadi do? Well, he asks his longtime friend and business associate, Mr. Almheiri, who Mr. Almheiri has known since 1998. I think that was a reference in day one. I think he said 1998 or in 1999. That's at day one, page 20, line 17. Now, of course, Mr. Almheiri couldn't do it himself, so he got Mehdi Dazi, his business associate, to help him. Now, Mehdi Dazi in turn involved his brother, that's also an accepted fact, Abdulaziz Dazi, as the chosen nominee to hold the shares in the two SPVs, EVL, ECL, as nominee for the UBO, Mr. Almheiri. And the reference there is in the claimant's own skeleton at K12492. Now, Abdulaziz Dazi does so, holds those shares, because Mehdi Dazi is, of course, having legal problems. We can see that at D92, page 1191. Now, Mehdi Dazi also engages Manil Nejar, who has the relationship with HSBC. And we can see in 2019 that Mr. Nejar reports back to Emadi, Mr. Almheiri and Mehdi Dazi on his, quote, assignment, end of quote, and explains that his assignment was to help you. And help you, of course, is a reference to whom the email was addressed to. So that's Emadi and Mr. Almheiri in relation to the termination of the guarantees. And the reference to that email is at D961184. A year later, in 2018, Mr. Nejar reports to Mr. Almheiri and Emadi once again, this time referring to the termination of the personal guarantees as, quote, his mission, end of quote, which he says he completed. And that's at D971186. Now, there's no reference in those emails to Ezelldine or Mr. Cameron, my client. Now, the fourth and final point to take away from the long list of facts that I set out in the opening is that after the restructurings, we looked at before, now we're looking at after, 6 of the 9 UBOs were let go. Mr. Araj now has possession or control of ECL and EVL. That's important because those SPVs hold rights to receivables of over $100 million and at least $27.5 million in assets. Mr. Cameron, of course, is left with nothing, but he's being asked to pay $25 million. Now, that's 15 times more than his original exposure of $1.7 million at the outset. So it's clear that something has gone wrong. And in the opening, we said that that something relates to the promises that were made to Mr. Cameron before he signed his agreement. So the first lie or the first promise that was given to Mr. Cameron was that Emadi would give a guarantee on the same terms as Mr. Araj and Mr. Cameron. Now, there was a suggestion made during cross-examination that Mr. Araj and Mr. Cameron would step in only once Emadi had agreed not to give a guarantee. Now, of course, that suggests that Mr. Emadi agreed to give a guarantee in the first place. But of course, that's not true. But it's evident from the very start, in July 2014, through to 2015, I'll come on to the evidence in a moment, that Mr. Emadi would give a guarantee. And it's also clear that Mr. Araj would also give a guarantee. And Mr. Almheiri accepted that Mr. Araj was intended to give a guarantee during his cross-examination. That's at day 1, page 124, lines 6 to 17. And Mr. Cameron was always under the belief that Mr. Araj had in fact given one. If we just pull up on screen D861112. And that's an email from October 2016, zoom in, where Manil talks with Baker and McKenzie, that's the lawyers engaged by Mr. ALMHEIRI, CCing Mehdi Dazi and Abdulaziz Dazi. And they talk about the fact that John didn't even know at that stage that Mr. Araj didn't give a check and that he didn't execute a copy of the guarantee. So that's in October 2016, well after Mr. Cameron had handed over his check in January 2016. Now, the second lie, we can close that, was that Mr. Cameron would get shares in the SPVs. And just to be clear on what we're saying there, and what Mr. Cameron is saying and has said in his third witness statement, that paragraph 31, is that he would get 25% of the SPVs on the purchase of the HSBC debt, because at that time you have 4 people who are continuing, and that's Imadi, El Araj, Mr. Cameron, and Mr. ALMHEIRI. So they each get 25% on the purchase of the HSBC debt, which happened in late January 2016, and we'll come on to that. And then he would get 50% upon the repayment of the QNB debt. Now, the 50% upon repayment of the debt, that's something that Mr. ALMHEIRI accepts, that John would get that, and he accepts that at paragraph 7 of his first witness statement, and he also acknowledged it during his cross-examination. And the reference there is day 2, page 46, lines 9 to 12. And there was a point made during Mr. Cameron's cross-examination about Mr. Cameron having issued his security check in 2016, so that's long after he signed the agreement, and that he is claimed to have known about the fact that Ezelldine didn't provide one, didn't sign an agreement, and the fact that that he would in fact not get shares in the SPVs. So we've gone through the fact he didn't know about the fact that Mr. Araj hadn't given a security check or a guarantee. And now we'll talk about the fact, well, why did he give one in January 2016? Well, he gave one in 2016, but that was before the loan was actually dispersed. So at that time, of course, the SPVs, the shareholdings in the SPVs couldn't be transferred, because through HSBC, optically, the same UBOs could not be parties at that time or have control of the SPVs. So it had to be after the debt was purchased from HSBC that restructuring could take place. Now, the loan was not dispersed until January 2016, so well after the QNB loan documentation was signed, and the reference is to paragraph 34 of Mr. Cameron's second witness statement. And then, of course, the monies were not transferred to HSBC until sometime after that. And that specifically, when I say after that, it's sometime after the 28th of January 2016, because that is when the assignment agreement between, or the purchase agreement between the SPVs and HSBC was signed. And the reference to that is at D62 and D63, pages 926 to 950. So at that time, when Mr. Cameron handed over his security check, QNB had just dispersed a loan. HSBC soon after signed the documentation, and at some point after that, the money was paid over to HSBC, and then the loans got transferred. So the debt got transferred across to the SPVs, and at that stage, of course, Mr. Cameron and others were free to go through with the restructuring. So the expectation was always for Mr. Cameron, as he explained during his cross-examination, that he would receive 25% at that stage. So together with Mr. Araj, 50. To quote Mr. Cameron, as soon as the HSBC loan was retired, and the remaining 50%, so that's 50% Mr. Cameron, 50% Mr. Araj, once the QNB loan was repaid. And he explains that at day 2, page 46, lines 9 to 12. So that deals with the sequencing of why Mr. Cameron did what he did. Now, another point that was made during the cross-examination was that Mr. Manil's memo didn't refer to any shares in the SPVs, so the second lie that I referred to. Now, that's because the memo concerns, and that's in the sort of first line of the memo, a summary of identification and security mechanism That's it. It's a very defined sort of scope of what's looking at. And Mr. Cameron made clear during his cross-examination, and he explains, to capture everything, you would need a book rather than a small memo. So there's a lot more to the story. It's a very focused memo and question that Mr. Neger is addressing here. And the reference to where Mr. Cameron says that is day 2, page 97, line 23.
Your Honor, sorry to interrupt, Nils. I just wanted to add an element here very briefly that is to do with the memo that Mr. Najjar produced. In his examination, Mr. Cameron was asked about the memo, and he was asked whether he was concerned about the check, and he replied in the affirmative. And you see, the memo was intended to explain the context in which the check was given, and that was owing to concerns that, taken out of context, that check may be used for other reasons. So I just wanted to make that point, sir, before we carry on.
Yes, thank you.
Now, I mentioned this point at the beginning, but the other point for this memo, of course, is that there's a certain narrative given to it by the claimant. But it's important to remember Mr. Neger also gave a witness statement, not in response or in request to what Mr. Cameron asked of him, but in relation to Mr. Araj's case. So it's important to look at that witness statement as well, not just the memo, and that's at C3154. Now, finally, during his cross-examination, Mr. Cameron was questioned.
So can you remind me of the reference to the memo?
So I can give you the reference to the memo. There's also a witness statement.
Yeah, you've given me a witness statement just now, but
the memo, I believe, is D98.
Yeah, thank you.
Yeah. So skip that. There's another point made in Mr. Cameron's cross-examination, where he was questioned about the fact that why there was nothing recorded in his guarantee about the MUSABEH guarantee or the SPVs. And Mr. Cameron's position on that was, well, he didn't need to. And as he explains, it was based on a high level of trust and the fact that the parties had worked together for many years. And I'll come back to this concept of trust. He says that in day 2, page 27, lines 17 to 20. And just with reference to, my learned friend makes reference to specific misrepresentations. What we have here is deceit. We'll come on to how that's different from fraud, so misleading someone. And Mr. Cameron's case is that this sort of deceit is a feature that is apparent throughout the course of the restructuring from 2014 to 2015. We're not looking at 1 or 2 examples. We're looking at a continuous continuum of communications as to what would happen with the restructuring, the fact that MUSABEH would give a guarantee and that there would be shares in SPVs that would be given to him and Mr. Araj. And we can see evidence of that right at the beginning of 2014. If we can pull that up on screen, D32538. Zoom in on that, and this is really the sort of the framework email in 2014 that sets out how things are supposed to happen with this restructuring. And very clearly in the second paragraph, there is a reference to the fact that MUSABEH will guarantee the personal guarantee. So the positive statement there that he will do it. It's not he may, he might. It's MUSABEH will guarantee. Now that features again, of course, there are various phone calls, but as Mr. Cameron explained, but in terms of the documentary evidence, that same sort of commitment features again in May 2015. So it's very close to signing. And that's at D43586. If you can pull that up, please. So later in 2015, nothing has changed. Again, the expectation is very much that Ali, that's Ali Al-Sharif Al-Mahdi, would sign a guarantee. And the email attaches copies of the indemnity agreements, as they're titled. They're sent to Mr. Araj, Mr. Cameron, and in no uncertain terms, it states that Mr. Mehdi Dazi would send it to Ahmadi for signing. That's the point of this email. Now, of course, Mr.
Sorry, Nelson, I'm going to interrupt again. I think just a minor point, Your Honor, but one worth making is I believe my my learned friend questioned what the reference to others meant. But in fairness, I think Mr. Cameron gave an explanation as who he thought the others might be, and you will find that in his witness statement. Sorry, apologies. No, you'll find that in the transcript, day one.
Yes, again, do you have a page number? If not, don't worry, I'll find it.
Yes, perhaps we'll come back to you a bit later with the reference numbers.
Thank you.
So Mr. Cameron had no reason to second guess what he'd been told in 214, again in 215, the fact that Ahmadi would sign a guarantee, and he operated entirely on that assumption. Now, there's a big point made about the fact, and I sort of mentioned this earlier on, that there's nothing recorded in the indemnity. Well, there's a lot of trust between the parties, and the word trust features a lot in the evidence. And I'll just walk through that evidence. Mr. ALMHEIRI, in his first witness statement at paragraph 8, acknowledges that there was a lot of trust involved. It's page 181. Mr. Cameron, during his cross-examination, made reference to the trust and long-standing relationship between the parties involved. Day 2, page 28, lines 6 to 9. And then finally, if we can pull this one up, page 211, paragraph 8 of Mr. Araj's third witness statement. Yeah. And that's Mr. Araj again saying, we did not conclude in writing the agreement I referred to above. That's the agreement with respect to the Ahmadi guarantee and the SPVs. And he explains that the reason for this is simple. At the time, I trusted those with whom such agreements had been reached. I had reason to do so. We'd worked in business together for many, many years. And we see that reflected in the evidence of Mr. ALMHEIRI and Mr. Cameron as well. We can, yeah, thank you. And we can also see it on the facts. So the whole Odyssey loan, asset purchase, equipment lease, that's not documented, but understood by all that that was intended to fund the loan, for example. With reference to Mr. Mahdi, it's important to note also that he doesn't just pop into the picture all of a sudden. He was first introduced to Mr. Cameron by Mr. ALMHEIRI in 2007. That's Mr. Cameron's second witness statement in paragraph 26. And as Mr. Cameron explained during his cross-examination yesterday, he was specifically told by Mr. ALMHEIRI to report into Mehdi Dazi. That's day 2, page 22, line 23. And we can see in the evidence, and I'll come on to the evidence in a bit, that it's very clear that Mehdi Dazi is acting as Mr. ALMHEIRI's agent, and there was never any reason for Mr. Cameron to suspect otherwise, and there's certainly no evidence to suggest that. Now, in the opening, we explained that Mr. Cameron was lied to, firstly, by Mehdi Dazi acting for Mr. ALMHEIRI in respect to the Ahmadi guarantee and the SPVs, and separately, the two are not to be conflated, separately, he was also lied to by Mr. Araj in respect of Mr. Araj's guarantee and security check. And we explained with reference to the documentary evidence why Mr. Cameron believed that and why it was reasonable for him to believe that Mr. Mehdi Dazi was Mr. ALMHEIRI's true agent. So to be clear, the representations with respect to Mr. Araj's guarantee and security check, we're not trying to attribute those to Mr. ALMHEIRI, They are representations made by Mr. Araj. Now, before going to the evidence, I just want to look at how the law on deceit in the Civil Code differs from the English law concept of fraudulent misrepresentation. They're very two different things. So we can just pull up on screen a table that we've pulled together. I appreciate you wouldn't have seen this table, Your Honor. I hope it's not contentious. It simply sort of summarizes, sets out the differences between the two. That's the wrong table. Table 1.
Am I going to be given copies of these tables?
Yes, we'll send those through to you. We haven't had much time, to be fair, to pull all this together. We've done the best we could.
But these tables set out your submissions on the certain legal points, do they?
Yeah, it's on the law on deceit, on UAE law, and how that contrasts with English law and the position. The authorities we have cited in support of the UAE law position are not new authorities. They're already in the bundle. In fact, it's an authority that the claimant, one of the claimant's authorities.
Just the record, we have received the table, so if we can receive those as well, we'd be grateful. Thank you.
Yes, of course. So the first point, looking at the distinction English law, UAE law, hopefully it will come up on screen. English law, we're looking at a false statement. We're looking at this.
Do you want to wait for it to come up on screen? Otherwise, I can't necessarily follow.
Yes, let's do that.
Is there any way we could be sent it now? Just because it's hard to see it on all the screens.
My lord, I just want to take the moment to address the reference I was making earlier.
Yes.
It is to page 67 of the transcript, lines 24 and 25, and page 68, lines 1 through 3, where Mr. Cameron gives a plausible explanation of who the others may be.
Yes, thank you. Thank you very much. Mr. De Wolf, are you able to transmit these tables to Mr. Bohr? And indeed, myself would be helpful.
Your Honor, I understand how helpful these things could be, but truthfully, which I do appreciate how helpful they could be, but truthfully, it is still a working draft, and so in between, for example, in between periods, with respect to the document itself, we may very well, supplement what we have in the document at the moment. So we're happy to share it on screen. We're happy to send it to both yourself and opposing counsel once the submissions are completed, if that could be helpful.
Well, I think it's useful. It's easier to follow the submissions if we have the document, because frankly, reading the thing on screen it ends up being quite small.
Understood.
And you
Well,
can't see the overall picture. And if I break for 5 minutes, could you email it across to Mr. Bohr and to my and the case manager?
Could I plead for your indulgence and ask for 10 minutes, because I would like to go through this document one last time before we send it.
I quite understand if there are changes to be made later when you've proofread it, but okay, let's stop for 10 minutes. It's now 10:47, 10:55 make it, which is 13:55 your UAE time.
Thank you, Your Honor.
But if meanwhile it can be, if it can be sent at the end of that period to Lena Qualley, that would be helpful. She can send it to me.
Very good. We are ready to proceed, Your Honor, and we have sent the documents to counsel and to the clerk's office and to counsel.
Lena, have you received anything yet?
Yes, Your Honor, I just received it and I've just sent it over to you.
Thank you very much.
Thank you.
If you give me a second then, before we resume, I'll just download. How many documents is it?
Should be 4 tables. Addressing different issues.
Right, hold on. Yes, thank you.
But before I turn,
Except I just lost, sorry.
Yeah.
That's okay, right. Yeah, which one do you want me to have open?
just before I turn to that table, actually, there was a point made in my learned friend's closing with respect to the MUSABEH guarantee and the significance of it. And the point was made that, of course, even if MUSABEH had been a guarantor, then Mr. ALMHEIRI, of course, could have come after MUSABEH, could have come after Mr. Cameron, but not Mr. MUSABEH. Mr. Cameron addresses that point in his second witness statement at paragraph 44, page 271. And of course, as a legal concept, it would simply be a case of Mr. Cameron joining Mr. MUSABEH as a co-guarantor in circumstances where a claim would only be made against him. And the concern about dragging Mr. MUSABEH into the whole picture, of course, being a public figure, that's a concern that's addressed, Mr. Manil Nejar addresses in an email that he sends. And that copy of that email is at 1187. Just wanted to make that point as well, but before we move on to the law of deceit. So if we pull up table 1, please. Very simple table, really. The English law position on fraudulent misrepresentation on the left, and then the UAE concept of deceit on the right. And that case you see there, Dubai Court of Cassation, that's in the bundle. It's a case that was cited by the claimants. So English law, we have false statement, dishonesty, reliance, and then the remedy rescission. And then deceit is very, very different to that. We have a misleading act, which could simply be silence in circumstances where you should have spoken out. No requirement for dishonesty. And then in terms of reliance, we're simply looking at inducing consent to something where the contracting party would not otherwise have given their consent. And then similarly, annulment in circumstances where deceit results in gross inequity. And that simply looks at the significance or materiality of the misleading act or acts that are sought to be relied upon. So the simple point is under UAE law, is deceit is not the same thing as fraud, and there's no requirement for dishonesty. And if we go to I2 2265 of the bundle, we can see that deceit in the UAE Civil Code, let's wait for that to come up. Zoom in just on the bottom of that page where it says deception and cheating. So that's deception and cheating. And there's a note just under that. The word translated as cheating is gubben, excuse my pronunciation, meaning trickery or persuasion of a person to enter into an unconscionable bargain involving an imparity between the consideration moving from each party. So you move down to Article 185, which defines deceit. And it's about deception, trickery, not fraud, dishonesty. And if we move to K41 2866.
Doesn't the word trickery suggest some sort of deliberate misleading, which is very different, very close to, or maybe the same thing as dishonesty? I just wonder whether it's a matter of translation that's potentially problematic.
It is, Your Honor, actually, and if I could just state the position as simply as possible, I think Dr. Hussain was actually quite helpful in the way that he explained this. And just reading from the, Niels, do you have the reference to the transcript?
Yes.
Yes, yeah.
It's page 65, line 19. I think my colleague can pull that up.
Of today's transcript?
From today's transcript, yeah. So it's just a live transcript. Should see that on screen.
Yeah.
That's how Dr. Hussain summarizes it. Again, no reference to fraud there.
Yes, I see. Yeah.
And
okay.
And the reason there's no reference to fraud is because the way that this is treated in UA law is in the context of contract formation, so the formation of a contract. And we can see that if we move to K41 2866. Just on the bottom of that page. Fraud appears in this section, section 2, which looks at validity and effect of the contract and the making of the contract. And then 129 talks about agreement and consent. And specifically what deceit looks at is defects in consent. If we move to page 2876, you can see that. That's where it appears. So defects in consent, you have duress, mistake, and then you have deception. So I'll move on how the evidence meets the test for deceit. So that should be table 2, Your Honor.
Yeah.
What it basically does, it follows on from the request you made yesterday to ask the parties to pull together the transcript references that you would like to be referred to. So it basically pulls together the evidence of deceit with reference to the documentary evidence that I cited in my opening on the first day. And on the right-hand side, you have the transcript references. So we have the different elements of the fact that KHALED was, so Mr. Cameron was deceived by Mr. ALMHEIRI acting through Mehdi Dazi. That's in Article 185. And then the evidence below that supports that, if we just go through, that he would be, that Mr. Ahmadi would be giving a guarantee, the fact that Mr. Cameron would get shares in the SPVs, the evidence that supports that. We then go through the fact that Mehdi Dazi was acting for KHALED. So we look at the concept of apparent authority and the evidence that supports that, and why it was reasonable, we say, for Mr. Cameron to have acted on reliance of what he was being told by Mehdi Dazi. And then separately, C, and completely separately, is D. D relates to the deceit not by Mehdi Dazi, but by Mr. Araj. So it's just important we don't conflate the two. There's deceit from Mehdi Dazi acting on behalf of Mr. ALMHEIRI, and then we have deceit from Mr. Araj, and that's set out in D. And then, of course, if you're not with us on 185, we just move back up to C, then it's sufficient that Mr. ALMHEIRI had knowledge of the deceit. That's a 190 scenario, which is different from a 185 scenario. 185 is deceit by one contracting party to the other. 190 is deceit by a non-contracting party, but the other contracting party had knowledge of that deceit. And that's the evidence there, reference to documents and transcript, that supports the fact.
Those two concepts would really, 190 and 185 would be treated in English law as representation by silence when you knew that the party was being misled.
That's slightly different. So there's a separate provision on deliberate silence equating to deceit.
Yes, I'm not sure I understand the difference between them.
Yeah, so we've got 185
Yeah.
talks about the definition of deceit, and that's deceit coming from one contracting party to the other.
Yeah.
And then you have another provision on deliberate silence that can amount to deceit.
Yeah.
Which ties in with the Article 185 scenario, so that deliberate silence is sufficient. And then completely separate to that is 190, where the deceit is not coming from a contracting party, but a non-contracting party, but the contracting party had knowledge of that deceit. So that's a 190 scenario.
I understand that. I can't quite see the difference in principle between those two scenarios. In either there's deceit expressly from the opposite party, or there's deceit by failing to correct something that another party has said.
Yes, so the latter one would be the 190 scenario, exactly.
Yeah, but okay, yeah. All right, yeah.
So we can close that. Don't want to go through all of that. It's just one important point just to remember is, Joanna, you have three people saying the same thing. And although, so that's Mr. Araj, Mr. Cameron, Mr. Nejjar, and although two of them are initially called liars by Mr. ALMHEIRI, and the reference is day 1, page 132, lines 8 to 13, Mr. ALMHEIRI later changes his mind and backtracks from that position. And that's reflected in the terms of the, now first settlement agreement, which he initially resisted to provide on the basis that he was irrelevant. But in fact, of course, it's highly relevant and undermines his entire case. In short, what the settlement agreement acknowledges is that Mehdi Dazi had extracted for KHALED's benefit Mr. Araj's indemnity agreement, as it's called. Now, the test for apparent authority is set out in the claimant's skeleton at paragraph 81, and that's with reference to a UAE case from the Supreme Court. We can just pull that up on screen. It's I-92276. And we can see what that case says on the law as to what the test is. It's very small writing, apologies. We do a control find for test. It sets out the test, what that test is.
I can't read on my screen.
The page number is 2276. Don't know if that helps.
Yes. I'll bring it up then.
Yeah, it's probably easiest.
Give me a second.
Of course.
I just closed that bundle. Page number what? 2276.
2276, yeah. About the middle of the page.
Yeah, good. hold on. Sorry. In the live bundle, what section is it?
It is I9, section I, and then tab 9.
Yep. And you want me to read this decision?
Decision, and then it says a parent agency, however, is only deemed to exist if, and then it sets out the test for a parent authority. Just so you have that test for reference.
Give me a second.
Sure.
Yeah. Is that very different from English law?
I believe not. It essentially comes down to two things.
Yeah.
It is relevant when we talk about entire agreement clauses and whether you can exclude fraud of an agent. We'll come on to that point. But just in terms of establishing the authority of the agent, it seems to be similar. We've got the third party, Mr. Cameron, believing in good faith that the agent, Mehdi Dazi, is authorized by the principal, that's Mr. ALMHEIRI. And two, there is an indication, that's the word used in the judgment, that the principal, Mr. ALMHEIRI, has granted authority to the agent, that's Mehdi Dazi.
Yeah.
So that's the test under UAE law. And what ultimately matters, therefore, is whether the third party dealing with the agent acts in good faith and believes the agent to be the true agent of the principal, regardless of the good faith of the agent.
Yeah.
And that last point is also a point made at 81(2) of the claimant skeleton argument.
Yep.
Now, there's no indication in this case that we see here in front of us, or any requirement for the third party, Mr. Cameron, to take any precautions, as it's sort of suggested in the skeleton, to make sure that what he perceives reflects reality. It's about an indication, and that the principal has granted authority to the agent, and the fact that the third party is acting in good faith. That's what we need to look at and be concerned with.
Yeah.
We say that on the evidence that test is met, and we set out the evidence on that in the third table that was just before you, on how that is met and reflected in the documents and the transcript.
Mm-hmm.
During the first day, I believe you asked us to pull something together on entire agreement provisions and then English law, UAE law.
Yeah.
We've done that. If we can just pull up on screen table 4. So we look at the English law position, UAE law position.
Yeah.
So the first point is a matter of evidence where you have an entire agreement clause. Does it prevent the use of pre-contractual materials? That's the first point there. In short, we say no, and that is relevant when we come to discuss the classification of the agreement as a guarantee, with reference to the wider transaction and the fact that there is reference to the transaction and transaction documents in the recitals, and in fact that some of the defined terms ask the reader to refer back to some of the transaction documents. So that's just a matter of evidence. The second point is looking at deceit, whether that vitiates consent. There's a difference there, English law, UAE law. And we talked about how that's reflected in UAE law, because deceit is sort of treated as a matter of contract formation, and does not really offer acceptance because you take away consent, because the consent was procured in circumstances where it would not otherwise have been given.
Yeah.
So different treatment there. And then there's a point made by Dr. Hussain about whether it's possible to exclude public policy. Position there is consistent. UAE law, you cannot exclude liability for fraud, gross error, grave error, and so on. And these are phrases that are used in various Dubai Court of Cassation decisions. We have the references there. And that appears with reference to Article 296. That appears under the heading tort, so it looks at tortious liability. But case law has found again and again that 296 also applies in certain circumstances to contractual liability. And it's in circumstances where a party is trying to exclude fraud for gross fault, unlawful acts, intentional acts, and so forth.
Yep. Yes, thank you.
You can take that off the screen. Thank you.
Thank you very much.
So we've looked at deceit. I'll turn quickly to the qualification of the contract as a nominate or e-nominate contract. I talked a lot about this point in the opening, so I'll just give you that reference. That's day 1, pages 64 to 74. And I just want to highlight 3 points from what I said before. The starting point is the fact that the concept of an indemnity as understood in common law doesn't exist in UAE law. And that's the judgment that you gave in 5 in Ream, paragraph 68, I think it was. And you can find that at J282478.
Mm-hmm.
And in the opening, I took you to the definition of a guarantee and how that's been defined in case law. And that case is DCC 202-2008. And we said there that that's a tripartite relationship. We have original or principal debtor who's liable to fulfill the promise. We have a guarantor who promises to fulfill that promise if the original debtor does not. And then we have a creditor to whom that promise is made. So in this case, we have EVL as the original principal debtor. It was intended to service the loan through the lease fees that it was intended to receive from GSS. That's accepted between the parties. You have Imadi, Araj, and Mr. Cameron as guarantors who would step in to fulfill that promise if EVL did not. And then, of course, you have Mr. ALMHEIRI, the creditor to whom that promise is made. Now, Dr. Hussain referred to the relevance or the significance of this time bar in 1092. And he says, I believe, it's to avoid creditor negligence. And to protect the guarantor from the consequences of a creditor's actions. I think those were the words he used. I think that's at 61:21. Now, of course, that's very relevant here, because what's happened here is exactly that sort of scenario that 129 is trying to avoid. Because before Mr. Cameron is even told about the demand from QNB, Mr. ALMHEIRI goes ahead and signs an agreement with QNB admitting the debt. You can find that at D106 and 1222. If you pull that up, please. So whatever defenses Mr. Cameron had, well, they would have been lost at that point by virtue of this agreement, which is a 1092 is exactly the kind of scenario that it is intending to avoid. 1222. I believe it's July 2019. That's an agreement between Mr. ALMHEIRI and QNB. If you keep going down, please. Keep going down a bit more. And a bit more. It talks there about an admission of a debt. As of the date of this letter, you failed to make any payments. And then at the top of that letter, there's reference to a claim of $30 million being the admitted debt at the top of that. So that's exactly the scenario that 1092 is intended to avoid, so that the guarantor, of course, who is exposed to that liability has a chance to raise defenses that it may wish to raise. And we also have the fact, of course, with the EVL equipment lease that was terminated by Mr. ALMHEIRI, and again that was done without Mr. Cameron's knowledge. So that's the point about guarantees and how they're defined in this tripartite context, why the time bar is so important. Now there was a point made in the opening and again in the closing about the significance of the security check. Now I addressed that in the opening with reference to a Dubai Court of Cassation decision with exactly the same scenario, a guarantee, and behind that you had a security check, and then the other party tried to encash the security check, and the court found, well, you can't do that because the security check is a means of payment that sits behind the guarantee and acts as security. And that's exactly what's happened here. So it doesn't turn the agreement all of a sudden into indemnity. It's simply a means of security that sits behind the guarantee. And the reference to where I've said that is at day 1, pages 65, 66, line 12. I also want to make a point about discharge. So that's Article 453 of the Civil Code, where you have a settlement with one co-guarantor. All of the guarantors are discharged. I believe my learned friend said that's accepted where it's a case of joint and several liability.
Yeah.
Well, this is a case of joint and several liability, and it's how the claimants have pleaded their case. If we turn to page 36 of the bundle, that's paragraph 69 of the amended particulars of claim. Wait for that to come up on screen. And it says, Mr. Araj, the second defendant, are jointly and severally liable. That's how they've pleaded their case. And so we say in those circumstances where you have a settlement with one guarantor and you don't expressly reserve your rights with respect to the other guarantors, well, that means that everyone is discharged. And Article 453 tells us that.
How do you reserve your rights? Do you have to tell the other guarantor at the time of entering into the agreement that notwithstanding the agreement with X, you are reserving your rights against Y?
It would be a reservation of rights provision clause in that settlement, yes.
But would that settlement have to be communicated to the other side at the time of entering into it?
Well, I think the effect of that in law, if you have a settlement without the reservation, then that liability is discharged.
It's not quite answering my question. I'm not quite sure. And what's the logic? If you're settling with A and you've got to reserve your position against B, but you can do so in a document between you and A, how is B better off if you've done that?
I think it's simply by operation of law that if you don't do that, the consequence is that the entire claim against the other co-guarantors is discharged. Yeah,
but it doesn't make sense because you can reserve your right against B simply by something you said to A without B knowing about it.
Can I come back to you on this, Your Honor?
If you can, yes.
Yes. I've made a note of it, so I'll come back to you. I then want to just turn on to the loss, so the issue of loss. I'll just refer back to the points I made in opening again. Day 1, pages 75, 76, line 7, and highlight just 3 points. The starting point again is the indemnity doesn't exist under UAE law. That's a 5 in Ream case. Second point, I'll take you to a judgment, is that liability under UA law has 3 elements. You have a liability, a damage, and then the causal connection between them. So if we just put on screen page 2591, that's an Abu Dhabi Court of Cassation 294, 2025. Again, a case cited by the claimant. The top of the screen.
Which case is it? Sorry, just for on the live transcript so I can see it.
It's Abu Dhabi Court of Cassation, case number 294-2025. It's at page.
What tab is it?
Maybe someone can help me with that. K7.
K7.
Yes. The difficulty of the tabs is that we have these judgments in Arabic and English, but the English doesn't necessarily follow the Arabic. So this is the English translation. It just looks at the concept of liability and what you need to show. So three aspects: liability, damage, and causal connection. So obviously there's an element of loss there that needs to be shown.
Yeah.
And when we look at quantifying that loss, putting a figure to it, Article 292 of the Civil Code tells us that that's limited to actual loss. And then another Dubai Court of Cassation decision 252/1993, that's at page 2631, just sort of explains that position. It's limited to actual loss that we're looking at.
Right.
We don't need to look at it now, but it just basically sets out the position of Article 292.
Mm-hmm.
It's limited to actual loss because, of course, in this case, the claimant is suing for prospective loss. Payments he says he is liable to make under a settlement with QNB. Of course, there's no certainty at all whether he will make those payments. So to the extent, therefore, that Mr. ALMHEIRI has incurred any loss, then we say that that's limited to the amounts he has actually paid to QNB.
Yeah.
Not that he may or may not pay to QNB in the future. Now the claimant tells us he has paid QNB 32 million. That's not the exact figures. It's around 32 million, but it's basically with reference to 3 managers' checks. You can find those at H5 2044 2046.
Yeah.
And I said this in my opening, but I'll just repeat the point that there's no evidence that these checks have actually been encashed. We just have copies of the checks. And there's no evidence that the money that sits behind these checks, now again, these are managers' checks, so they're issued by a bank once you put the bank in credit. So you send money to the bank, and then the bank issues these managers' checks. And there's no evidence that this money that sits behind these checks actually comes from Mr. ALMHEIRI. And when we look at the evidence, it seems highly unlikely that the money could have come from Mr. ALMHEIRI. Because when we asked Mr. ALMHEIRI in correspondence for a list of his assets, and we referred to a list of assets that the court in the markup proceedings pulled together with assistance from the creditors, there's not much there, and we asked him to disclose any other assets he may have, the only response we got from Mr. ALMHEIRI, and I'll take you to that response, is that the equity in a building, in a property, was at most 1 million dirhams. And that's at paragraph 11 of his 8th witness statement at 22002201. 2201. If we can just pull that up on screen. Yeah, so paragraph 11, he looks at the equity in a building, which is one of the assets listed in the list of assets that was provided in support of the security for costs application. And he basically explains the estimated values between 35 to 38 million dirhams, and that there's currently a 37 million dirham mortgage on it. So, and the second point to make is that with these assets, the timing, of course, of when these checks were issued. It's a check that was issued in January and another one in May 2004. So that's in very close sequence to Mr. ALMHEIRI's transfer of EVL to Manil Nejar, which he says was for the benefit of Mr. Araj. And he says that during his cross-examination at day 1, page 138, lines 12 to 15. And that transfer was, of course, made in December 2023. So there's a real question mark around the provenance of the funds that sit behind these managers' checks. And of course, if the funds did not come from Mr. ALMHEIRI, which seems to be the case, then it's not his loss to pursue. Because otherwise, you could have a person or a company come to court tomorrow and claim the same loss that Mr. ALMHEIRI is pursuing as their loss. Now, if you're not with us on loss, Your Honor, then we have subrogation as an alternative argument. And again, I'll just refer back to what I said in the opening. That's day 1, page 76, 77. And just 2 points to highlight here. There's a clear right of subrogation under Article 463 of the Civil Code. And where you have co-guarantors, and one of the co-guarantors discharges the debt, then you can go after the other co-guarantors. Now, of course, what we have here is a situation where we had 3 guarantors. We're supposed to have 3 guarantors, Imadi, Mr. Araj, and Mr. Cameron. But only Mr. Cameron is left, and he's effectively lost his ability to exercise that right of subrogation. He can't go after Imadi, and he can't go after Mr. Araj because his agreement has been deemed null and void. Just one more point before I just come on to the concluding remarks, and that's with respect to mitigation. I'll refer back to the points I made in the opening on that. Day 1, page 77 to 80. And just to highlight one point here, really, we say that duty to mitigate is apparent from a combined reading of Articles 2461 on good faith, and then 290, 292, and 389, which talk about there being no liability where a creditor contributes to their loss. And so applying that on the facts, through Mr. ALMHEIRI's actions, very simple terms, the QNB loan went from a secured facility, which had the benefit of a pledge of $27.5 million in assets, to an unsecured loan. Now, that is not what was intended, and it's certainly not the circumstances in which Mr. Cameron's agreement was issued, and that's clear from the recitals of that agreement. The very first thing says Mr. ALMHEIRI is entering into the transaction documents, and within the definition of transaction documents you have asset pledge, equipment lease, and all these other agreements. So all that is lost, and it's effectively an unsecured loan. The other point, just to flag in the context of mitigation and the failure to mitigate, are these transfers of EVL and ECL. Now, I won't talk about the settlement, so I will just proceed on the assumption that will not be admitted into evidence. And simply make the observation that those transfers seem to have been made for nil value, but they're not insignificant transfers. And they were the same assets, that's the GSS assets, Odyssey assets, that were intended to fund the QNB loan. So at the very least, we say that these two elements are proof of the failure to act in good faith. Just a few concluding remarks. At the point of the restructuring, it's important to remember that we had 4 parties at the table. You have Mr. Cameron, Mr. Araj, Mr. ALMHEIRI, and Imadi. Now, Mr. Cameron and Mr. Araj appear in the papers. Mr. ALMHEIRI and Mr. Imadi do not. Instead, it seems 2 new faces appear. We have Mehdi Dazi and also at times Emmanuel Nejjar. Now we know Mehdi Dazi was introduced by KHALED. KHALED tells us that himself. That's paragraph 13A of his 6th witness statement. And Mr. Cameron told us during his cross-examination yesterday that Mehdi Dazi was representing ALMHEIRI in the restructuring, and he was told by Mr. ALMHEIRI that all communications should be routed only through Mehdi Dazi, and that's day 2, page 22, lines 20 to 23. And that's exactly what Mr. Cameron did. We can see that reflected in the evidence. And there was no reason for Mr. Cameron to ever suspect that Mehdi Dazi was anyone other than Mr. ALMHEIRI's agent. He certainly wasn't told otherwise, and there's no evidence to suggest otherwise. Now, I showed you to this document earlier, the July 2014 transaction framework, as it's called. That was shared by Mehdi Dazi with Mr. Cameron, and from that email, it's clear that Mr. El-Mahdi would provide a guarantee, and that's at D32538. Now, we heard from Mr. Cameron when he gave his evidence that over the course of the transaction, that's 214 to 15, he was variously told again and again that he would receive shares in SPVs and that El-Mahdi would provide a guarantee. And we looked at evidence of the fact that those representations continued well into 2015. And we looked at an email from May 2015 from Mehdi Dazi asking Mr. Cameron and Mr. Araj to sign their agreements, and that Mr. El-Mahdi would receive his agreement for signing, and that Mr. Dazi would deal with that. Now, Mr. ALMHEIRI, of course, knew that Mr. El-Mahdi would not provide a guarantee. He accepts as much. But on the evidence, there's no evidence that either he or Mehdi Dazi ever told Mr. Cameron. And it's clear that even in October 2016, Mr. Cameron did not even know that Mr. Araj had not given a guarantee or a security check. And we looked at that email, and that's a D82112. So we say it's clear on the evidence that Mr. Cameron was misled. He was misled by those he had trusted and put his faith in. And while Mr. Araj now has very valuable assets in excess of $100 million, which were transferred to him by Mr. ALMHEIRI, for what we were told, at least initially, was for nil consideration, Mr. Cameron has nothing. Now, to make matters even worse, Mr. ALMHEIRI claims from Mr. Cameron sums he claims to have paid to QNB, but failed to even remotely evidence. Your Honor, this is not a case of a deal gone wrong, but of deception. Now, you've heard from two witnesses. We say Mr. Cameron is the more credible one. He came across as competent and worthy of belief. He was forthcoming and answered all questions that were put to him. Then you have Mr. ALMHEIRI. He was evasive with his answers, and when faced with difficult questions, couldn't give straight answers. For example, when asked what he received in return for EVL, he had no answer to give, and instead referred back to the settlement agreement he had signed with Mr. Araj, which of course says nothing about the transfer of EVL. And that's at day 1, page 317 to 140. Sorry, day 1, page 137 to 140. And ultimately, he conceded that, I'm quoting him here, that he simply doesn't recall. And that's day 1, page 139, line 24. Similarly, when he was asked about the transfer of the HSBC debt, he refused to even acknowledge that there was no reduction in the debt. And that's at day 1, page 107, line 10 to 25. And finally, when he was asked whether Abdulaziz Dazi, Mehdi Dazi's brother, held the SPVs on his behalf, he denied it. And that's despite the fact that his own submissions tell us otherwise. And that's day 1, page 93 to 95, lines 18 to 20. So we say the evidence is clear. It shows that Mr. Cameron was misled, and that Mr. Cameron's consent was procured in circumstances where, had Mr. Cameron known the truth, he would not have given it. And the consequence of that under UE law is clear. The effect is that consent is vitiated and the contract falls away. And we see that Article 187. And we say the entire agreement clause that the claimant relies on in that context gets them nowhere in such circumstances. Thank you.
Yes, thank you very much. Now, Mr. Bohr, are you going to want to make some reply submissions? We've got half an hour allowed by the programme for you to do that.
Yes, I am indeed. I don't know whether you want to break now or you want me to go straight into that.
It depends.
The other thing.
The timetable allows you to have a half-hour break before doing that if you want, but you may not want to.
Okay. I'm being asked if that's okay. Yes.
What, to have a half-hour break? Yeah.
Yes.
That's built into the timetable, so yes. Is there anything you want to say before that?
Only that an application was made, although there are provisions of the court to allow evidence to go in. I mean, the point that we just heard is quite relevant because reliance is being paid on a settlement agreement, which is no longer binding between the parties, and there has been a change of, apart from everything else, a change of facts in the sense that there's settlement.
You're talking about the new document.
Yeah. Yeah,
I haven't read it. I don't want to be told about it until I allow it in.
Yes.
So there's no good sort of talking about its consequence unless you first of all succeed in admitting it.
Yes.
Do you want to address me on that basis, or do you want to do that after your submissions, or as part of them?
I'm happy to do that. I'm happy to do that now, if that's okay with you. Otherwise, I can do it after the break.
Well, do it now. If it will give the other side a chance to consider what you say.
Yes. So again, I'll make a point of not addressing the contents in any detail, but rather explain why we say it should be admitted. And so the first submission is that an order was sought at the PTR for us to disclose settlement agreements with Mr. Araj. We had already disclosed the one that's before you, but there was some suspicion that another settlement agreement had been entered into because the DIAP proceedings had been withdrawn. And we had said that settlement discussions were ongoing. And so this, in a sense, is a continuation of that. We are providing this settlement agreement to the other side as required. The second point is...
This document is dated yesterday, is that right?
Yes, yes.
After your client has given his evidence.
Yes.
And it couldn't have been covered. It couldn't have been covered by the original request because it didn't exist.
It didn't exist. And so that's our second submission. That there's essentially new facts which should be before the court.
But if these are put before the court, wouldn't there have to be further cross-examination?
Yes, so that's the point I was going on to. The claimant is happy to appear, subject, of course, to the court allowing this to go in, to be cross-examined on the settlement agreement, and make himself available, I believe, today. Yes.
Well, but why was this document? Well, without going into the content, doesn't this document really have the effect of being further evidence by Mr. ALMHEIRI after he's finished his evidence?
Well, firstly, it would say even if it was, the court can allow, and we say should allow. Can you hear me, my lord?
Yes, I can hear you.
Okay, I can't see you, but nevertheless, I'll carry on speaking. The court can, and we say should allow new evidence because if there are new factual matters that should be determined. So in that regard, we say it should be allowed. But more importantly, the other side want to rely on the null and void point and also the discharge point. And so this, I mean, without again wanting to go into the context, the settlement deals with both those points, in a sense.
It will be back in seconds. It automatically.
Yeah.
But you have to click continue watching.
My lord, I lost the sound.
I can hear you. I can see you too.
Okay.
Very secret hiding the contact.
Okay. I'm just being told that the claimant can come today and sort of give evidence immediately on this one point. It's a very short document.
Well, the trouble is a short document can open up lots of potential questions. Well, look, shall I just hear what the other side say?
Yes. Can I just address you on that last point that you made about opening up questions? I mean, part of the most clearly, the parties to the settlement agreement were prompted to get their act together due to these proceedings, undoubtedly. But what we would submit is actually, in contrast to opening questions, we say the opposite is the case. Actually, what the settlement does is regularize the position which we say exists and actually makes things a lot simpler. That's my submission.
You're now giving evidence about the content.
Well, I'll leave that to the claimant if you allow me. Thank you.
Who wants? Which of you, Mr. De Wolf or Mr. Boumahab, is going to respond to this?
My lord, first of all, I say all of the things that you have said. And I echo your observations about this very peculiar and irregular request at this time. In simple terms, I believe what is being asked is, after having heard a witness who is not satisfied with the points that we put to him about his settlement agreement, he has gone home and agreed to do a deal. So essentially, he's gone home and fabricated evidence. And now he would like to put this evidence before the court, and he would like the court to hear him again. Leaving aside the issues that causes with respect to procedural fairness, I cannot see how that evidence would be admissible at this stage. So I leave it in your good hands to determine the point. I would also like to say, for the record, if you're with us, Your Honor, can you hear us?
I can hear you, yes.
I would also like to say that I have a 5-year-old I haven't seen for 3 days, and this would be his first time on the record. So yes, I would rather do that than cross-examine Mr. ALMHEIRI, as pleasant as that may be.
Yes, thank you. Mr. Bohr, I'm troubled by this because it's not as though you're giving late disclosure of a pre-existing document, which often happens, shouldn't happen, but does happen sometimes. This is seeking to adduce in evidence something Mr. Boumahab says fabricated, but in a non-pejorative way created after the end of the evidence in the case. And it doesn't seem to me that it really falls into any of the categories where late disclosure of a pre-existing document is sometimes allowed. There's no absolute rule, but it doesn't seem to me that it's justified in the present case, and so I'm going to disallow your application, refuse your application, and I'm not influenced in that. Although personally sympathetic, I'm not influenced judicially by the reference to the 5-year-old. We've all been in that position, I expect, and we just have to take it on the chin. But but I'm not going to allow your application. You've gone silent. You're muted.
Thank you.
So would you like, how long would you like before you begin your...
Hold on. Let me just take instructions, because I can see that people have itchy feet. Just hold on 1 second. Can we just have 20 minutes in that case? My lord?
Yes, 20 minutes is fine. So we'll resume at just after 12 UK time, 3 UAE time.
Yes, my lord. Thank you.
Thank you very much. Are we all ready?
Yes, my lord.
Yes. Well, Mr. Bohr, your picture says you're muted, but I can hear you. So
Yes, because it's muted on my laptop, but it's on the big screen, so don't worry about that.
I see. Fine.
Yes.
Anyway,
Okay. Shall I begin, my lord?
yes, of course. Yeah.
Thank you. I'm going to use my the very helpful tables that have been produced by defendant counsel, for which I'm grateful. And I think it's probably just best to sort of turn the pages on that and give us our reaction, give you our reaction to that. So the first point, just looking at table number 1, this point that there's no requirement for dishonesty. So I'll leave that to Dr. Hussein primarily, but our observation is, as your lordship recognises, that there's a word trickery in there, and therefore there would be something akin to dishonesty that's required under Article 185, etc. However, on my learned friend's case, if in fact we're looking at a right of action which is more akin to innocent representation or something of that sort, then what comes into sharp focus is the entire agreement clause. Because on any basis, an entire agreement clause would be effective when coupled, I should say, with a no reliance clause, as I pointed out this morning. That should be effective against a regular misrepresentation claim. So my little friend can't have it both ways. Either this deals with dishonesty, in which case there's no dishonesty, no evidence of that, or else the entire agreement clause bites and the case fails on that point. That's the only point on law I'm going to deal with. Turning then to table number 2, where you have the evidence of deceit. Dealing first with the deceit or the alleged deceit in relation to the intended guarantee to be given by Mr. Ahmad. The easiest way to deal with this is to turn up page 538 again.
What tab is that?
That is D32.
D32.
D.
Sorry, I've got so many documents open on my screen at the moment.
I know how that is.
Right, it's just coming. And this is in the context of table 2, is it?
This is right, yes. So what table 2 does is contain what's said to be the evidence of the deceit. So I mean that's crucial. This is said to be evidence of dishonesty, and there's a reference. Well, there's no reference in this particular table. Reference hasn't been made. Actually, there is a reference to this document in the table, and this document you would have seen a number of times. And what's being relied upon is point 2. That the loan will be guaranteed by the SPV, and after the transaction, the company, and as it was suggested by KHALED and Mahdi. And what we've said about this is, firstly, this is mere opinion or suggestion, to use the words of this email. It's an email that's not being sent to Mr. Cameron. It's an email that Mr. Cameron is commenting on, and it's an email that predates the indemnity by over a year. It's an email also where you can see on the wording of number 2 that the suggestion isn't being made by the claimant. It's not even being made by Mr. Dazi, the alleged agent for the claimant. The suggestion was being made by KHALED Ahmadi. The real complaint, therefore, of Mr. Cameron, to the extent he's relying on this, is that it's Mr. Ahmadi who is suggesting or suggested that he make an indemnity, but hasn't delivered on that suggestion. I mean, we say it doesn't come anywhere near to being a representation that's alone a deceitful one. But to the extent that there's anything to take from this, it clearly only refers to something that's being said by Mr. Ahmadi. Similarly, with the other points in this table, I mean, none of them deal with go to the heart of the alleged representation. The reliance on on Mr. Nejar, we say is unsound because of the multiple hearsay aspect. I mean, the table said that MN states that JC was lied to with respect to the provision by Ahmadi of a guarantee. But what we say is that that information comes from Mr. Cameron himself, and one can't take that, doesn't take the call very far. And then you say JC, there's also on the second page of the table, JC was informed that Ahmadi had already signed an indemnity agreement. Well, that's a completely new point. What the defendant has done in cross-examination is turn a representation in relation to an opinion into a representation in relation to fact, perhaps realizing that the representation in relation to opinion is not going to be helpful. And we say it's too late, and it doesn't accord with what's actually been pleaded. More to the point, the table itself doesn't state who told Mr. Ahmadi that it had already been signed, because what we heard yesterday, that it was at least Mr. Araj. And my recollection is that it was only Mr. Araj who was talking about a past signed agreement. But even if that's wrong, we say that this argument doesn't go anywhere for the reasons that I've already said. Then the next representation, get the shares. Well, I dealt with that extensively. And what's missing from this table is the reference to getting the shares once the QNB loan has been repaid, which is, of course, is a completely different beast, because that never happened. In relation to the 25% interest, the actual pleadings themselves don't state when they were meant to be paid by, but what Mr. Cameron did in cross-examination was try and link this to the HSBC repayment. In other words, the repayment of the HSBC loans. But that came very late on in the day, firstly. So to the extent that there was a breach in relation to that, that would have been for a very short period of time. There's no evidence for that in the witness statement evidence. It's something, again, which is new, which we say the court should not find in Mr. Cameron's favour in relation to. And we say, in the end of the day, it's not a material breach, even if it was a breach of a fraudulent misrepresentation, because in the end of the day, having 25% interest, just simply holding that for the short period that the loan was going to be outstanding until the loan is repaid was neither here nor there. What Mr. Cameron has actually pleaded is that he was promised control and ownership of the company, which would only come once the QNB loan is repaid. Absent from this table is a reference to the equipment lease, and that wasn't really dealt with in my learned friend's closing, perhaps because it's now appreciated that representation goes nowhere, given the fact that it's dealt with in the QNB facility and has been admitted by Mr. Cameron not to have been intended until 2016, when it was in fact signed in relation to GSS. So that falls away. We would also make a point about credibility. Given the fact that representation goes, one should also doubt the credibility of Mr. Cameron when it comes to the other representations. Moving on to MD acting for CAM. I go back to the points I said before. We say there's a misunderstanding on my learned friend's part. We accept that Mr. ALMHEIRI introduced Mr. Dazi. He had some relationship with Mr. Dazi. He also, as we've seen, is in correspondence with Mr. Dazi when it comes to terms of the indemnity agreement. We looked at an email earlier. But nevertheless, overall, and this was accepted, we say, by Mr. Cameron, Mr. Dazi and Mr. Najar were acting for the benefit of all of us. Mr. Cameron repeatedly used the word we. He said, and he also said, at least 2 occasions, we're all in this together, or words to that effect. And our point is simply this. One cannot assume, therefore, when you're dealing with an individual who is acting on a restructuring for the benefit of numerous parties, that everything that comes out of that person's mouth constitutes a statement that comes from one of those parties. And certainly, when it's something which relates to the restructuring, like control or the equipment needs, for example, then Mr. Cameron ought to have been put on inquiry, to use English agency terms, and gone back to Mr. Dazi and says, can you confirm that you have spoken to the claimant and he is sure that these things are going to happen, or these things have happened? more to the point, which isn't even alleged, of course. And so we say, therefore, there was no agency arrangement with Mr. Dazi in relation to these matters. But even if there wasn't such arrangement, then Mr. Cameron was on inquiry and should have made some inquiries about it.
إذا كان negligent أنا كنت غبي يعني يعتبر هذا.
Mr. Dr. Hussain, you're not on mute. Sorry. Then we're moving to the next page of the table. If JC not misled by Cam, then in any case, Cam had knowledge of the deceit. Well, that simply is not true. There's no evidence to show that the claimant had knowledge of any deceit. Just taking the words here on this page, Cam and Imadi went back on their agreement that Imadi would provide a guarantee. But Mr. ALMHEIRI said he did never believe that Mr. Imadi was going to be providing a guarantee at the end of the day. Cam knew that Imadi would not be providing a guarantee. Well, again, well, he knew that, but he didn't. What he didn't know was that Mr. Cameron was told that, if indeed he was told that. And finally, Cam told by Imadi Dazi on the 11th of October that come 15th of October, it would not be EA or MD that is in default, but Cam. The relevance of that point is not understood. Then the rest of this table, or the next page, deals with the allegation that JC was misled by Mr. Araj. So again, this goes back to the point before. You have a flip-flopping of Mr. Araj's role. Is he a victim or is he someone who's misleading Mr. Cameron? And then the final page just on general comments. So those are the main ones. The other points of law I'm going to leave to Dr. Hussain. Just dealing with the issue of reservation. The particulars of claim, to the extent they refer to just and joint and several, we say that is not actually correct as a matter of law. We have in our skeleton argument introduced the concept under UAE law of solidarity, and Dr. Hussain will speak to that. The other issue is one of reservation of rights. The court will recall that the settlement with Mr. Araj, or the initial settlement, was done in the context of these very proceedings. Mr. Araj was then removed as a defendant from these proceedings by order of the court, but Mr. Cameron remained a defendant in these proceedings. And we say that in and of itself, so that was enough to indicate to everyone concerned, including most importantly Mr. Cameron, that matters have not been settled and fully discharged. And in terms of the amount of the loan, Mr. Araj has not. Firstly, didn't comply with the agreement, and has not discharged the full extent of the loan, very, very far from it. In terms of the payment, what's been said and loss, what's been said is that we haven't suffered any loss because there's no evidence that the management checks have come from us. Well, our first answer to that is the court should accept the claimant's evidence on this, that he is obliged to pay QMB and has so done. There are the management checks at H13. They don't in themselves reference the claimant. I'm being told that there are instructions which are out there which do reference the claimant company, and they can be provided.
Mr. Bohr, we can't at this stage have further evidence.
I understand.
Not
So
even something as though under pretense of a submission.
I was about to say, but I understand that we can't put that in unless the court gives us permission. But you're indicating that you're not going to give us permission. I assume.
I haven't had an application yet.
No, so that's what I was going to come on to. I was going to come on to if the court is minded to gain some additional certainty, we say the court should accept Mr. ALMHEIRI's evidence on its face. But if the court is minded to gain some further certainty, on that basis we would apply to put in the instructions for the management checks, which are simply a handful of documents.
Mr. Bohr, you can't make an application conditional upon what the court is thinking.
Okay, in that case,
Either
I
making
think
an
the
application, or you're either making an application or you're not.
I think I'm gonna have to, and I do, with apologies, make a further application then on that basis.
What are you applying for?
I'm applying for permission to be able to put in the instructions for the management checks, which are being challenged by the other side.
Well, the problem with that is questions have been raised about these management checks for some time now in the context of this litigation, and they haven't been disclosed. Why should I allow it? Why should I now allow it?
Well, the overriding objective, one would say, in terms of doing justice, and the force in which those points are being taken in closing. But other than that, I have to accept the point that requests were made previously in relation to this, and the documents weren't disclosed then. I mean, as I say, my primary submission is that there's enough evidence for the court to say there is a court sanctioned settlement with QMB, and Mr. ALMHEIRI is indicated that he's been paying under that. That liability is out there, and that should be sufficient. I mean, it's noteworthy that the indemnity agreement itself has a conclusive evidence clause in relation to internal accounts, but we're not dealing with that. But the one could take from that Mr. ALMHEIRI's word in relation to these matters should be given some serious weight. That's the highest I can put this matter.
Well, given the history of this matter, I don't think I can properly. I don't think I should properly allow documents in at this stage which have been available and have been asked for and have not been given beforehand in response to legitimate questioning. So yes. I refuse that application.
Yes. I'm just checking my notes, my lord. I don't think I've got very much more. So then to finish off, I have a few points which my learned friend raised at the beginning of his closing submissions.
Yes.
One of the points he was saying was about the net exposure, and he was talking about what's Mr. Cameron going to get from all this, and he made the point that initially he was only exposed to a small amount, and now he's got a much bigger risk. And there are two responses to that. Firstly, it's not true to say that Mr. Cameron wasn't exposed. He was jointly and severable liable for the entirety of the HSBC loan. If HSBC had focused their attention on him, of course he could have joined in other parties. There may well have been the rights of subrogation, but that would all, whether or not he could actually get into those assets, would all depend on the value of those assets, the ability, the liquidity in relation to them. There's a lot of contingencies that apply. So that point you say is certainly shouldn't be given much weight. But the second point is in relation to what Mr. Cameron was going to get from this arrangement. And the answer to that is straightforward. Mr. Cameron knew that the other UBOs, other than Mr. Araj, his associate, were not interested anymore in this company, which was straddled with debt from HSBC, and now just taken a 25 million loan with machinery and the like. And he felt that they were going to back away if he was willing to put an indemnity forward. Then him and Mr. Araj, he believed, would gain control automatically by the fact that everyone else would have disappeared. The claimant didn't want involvement, and neither did anyone else. So it was just him and Mr. Araj. And if he could turn this around, he had expertise in the steel industry. He had operational experience, as did Mr. Araj. They were signing documents on behalf of the company. They were the only two really, it seems, involved, and therefore he was going to gain these companies at value, we would submit, and that was enough for him to take this risk. And really, the court needn't look no further than that. In a sense, we then come really to the overarching feature here, because what Mr. Cameron is asking your lordship to believe is that from as late as November 2017, he didn't know the true position prior to that date, and then from November 2017, he came into knowledge of these alleged misrepresentations. He made no attempt to raise these with anybody including, it seems, Mr. Nedjar, who we met in Paris in November 2017. And therefore, they're not fully reflected in this memorandum of Mr. Nedjar, which all seems to be about the security check and the indemnity, but focusing on Mr. Daz's wrongdoing as opposed to the claimants. And then you come to the proceedings, and suddenly these things become all important for him. In a context where we've seen that when things are really important for Mr. Cameron, what he does is have them put in writing, as he did in relation to the indemnity agreement and his negotiation of that. And we say, on that basis, the court should not be persuaded by Mr. Cameron's overall submissions in relation to this case. And our client, who have made it very clear in this email that we've gone through so many times at 538, was not willing to take any risk or liability in relation to this matter at all. And yet what Mr. Cameron wants him to do is to essentially swallow the liability for QMB, while Mr. Cameron can walk away and try and find some other business. Well, I don't have any further points, but I do want to hand over to Dr. Hussain, if I may, for the remainder of my time.
Yes, of course. Thank you very much, Mr. Ball. Dr. Hussain, do you have some points you want to make in reply?
Yes, my lord, actually.
Can I just explain, Dr. Hussain, you understand the nature of a reply is to deal with points made by the other side in their speech?
Yes, yes, this is my intention, my lord. I'm trying to reply on issues raised by my late colleague, actually. So basically, Your Honor, the defendant primary defense was alleged misrepresentation, but I decided in the morning time to start first of all with the time bar, which is secondary. So now I want to tackle the issues of misrepresentation. Article 185 requires deception, تغرير, through tricky خداع. خداع means deceptive. So basically it's, as you, my lord, mentioned, it's need action, it need intention. So leading party to consent where the other one wouldn't not. Article 185 implies dishonest intent. So basically it should be intention. If A was reckless, it does not include in that situation. So basically, otherwise, everybody would say I was reckless or I was, my intention was not. But it should be intention. Intentionally, he was tricking the other party or deceiving. Khida is a very bad word in Arabic. It means that tricky, deceived, try to take something is not in his position. This is not the only condition for Article 185. The jurisprudence of UAE court stated that one aspect you have to prove there is a deceit from the one party, where they are, otherwise you wouldn't be in the agreement unless his deceit was proven. Then other aspect is gross unfair. So the two elements, and this position is a clear position of UAE, which came from jurisprudence of Maliki school of Sharia. In contrast to other position of other countries like Saudi Arabia, because you need to only prove there is taghrir or deceit without gross unfair. In UAE, you have to have two elements. For example, this is a very famous example. We see it in court. For example, one wanted to buy gold. However, he went and bought bar of metal instead. However, if he is buying gold, for example, Swiss bar or UAE Emirates Mint bar, this is not gross unfair because the difference would be 500 dirham. As to confirm my position, actually, for example, the Appeal 41 of 2024 and Bundle I-11, claimant skeleton paragraph 72, the party alleging deceit must provide clear evidence of it. The authority also suggests of this case that such deceit must often lead to ghubn fahish, gross unfair. So basically the court is saying not only you have to prove taghrir, deceit, intention for deceit, but as well you have to prove that there is a ghubn fahish, gross unfair. Same position has been established as well by Abu Dhabi Court of Cassation in Appeal 373 of 2025. I-15, claimant skeleton, similarly confirmed that deceptive mean must be proven and that they were the decisive motive for contracting. In our submission, defendant here has neither alleged, let alone proven, any dishonest intent on the part of the claimant, nor demonstrated any resulting gross unfair. So both elements of the Article 185 was not established. Simply, he fails to meet the high threshold of this paragraph. Secondly, the indemnity agreement bar reliance on the external's representation. Even if the defendant could hypothetically, I don't agree with it, somehow suggest misstatements were made, which of course we firmly deny, his defense faced an immediate fundamental hurdle under clause 17 of indemnity agreement itself, claimant skeleton, paragraph 75. The indemnity agreement constitutes the entire agreement, superseding any previous statement or representation, whether written or oral, and neither party relied upon any statement except as expressed as out in the indemnity agreement. In applying the general rule that I spoke today morning, a provision of UAE Civil Code, we can conclude this clause do not violate any principle of UAE public policy, neither Sharia jurisprudence. Your Honor, such clauses are routinely upheld by UAE law, reflecting the core principle of UAE law of Pacta Santa Servanda. That agreement must be kept, al-aqd shari'at al-muta'aqidin in Arabic language. This principle is enshrined in Article 246, subclause 1 of the Civil Code. It's in bundle I3, which mandate performance according to the contract's content and good faith. And Article 257 in bundle I3, which confirmed that the primacy of the party consent as reflected in the contract. It directly contradicts the notion that he was induced by external representation. As well, my lord, if we go to Article 265, the UAE civil transaction, as well pertain to the interpretation of the contract. It states clearly that the literal interpretation, if the wording of the contract is clear, it may not be departed from by way of interpretation to ascertain the intention of the party. So basically the clause agreement constitutes the entire agreement is clear. So basically when we are interpreting this clause, we have to literal interpretation because the wording is clear and we cannot deviate to look to the intention of the party because the wording was very, very clear. Now further, Your Honor, I recite the principle, يا أيها الذين آمنوا أوفوا بالعقود. It's not only which translate all you who believe, fulfill all contracts. Means that it's not legal obligation, it's a religious obligation to fulfill the spirit and letter of the contract. Clause 4.3 of indemnity agreement in bundle D54 878, claimant skeleton, paragraph 77, contained that the defendant own warranties that he took independent advice or choose not to, understood the risk, and entirely willing without undue influence. He cannot now credibly complain he was misled or unduly influenced when he expressed warrant the opposite. Your Honor, the defendant attempt to rely on an alleged statement outside of the four corners of the very document he carefully viewed and signed is barred by the contract itself and the fundamental principle of UAE law, which I explained at the moment, which should be applied in the clause. Your Honor, neither deceit or nor agency is established. Your Honor, defendant case on misrepresentation face further quite fundamental difficulty. Article 185 of the Civil Code in bundle I2 speak of deceit by one of the two contracting parties. Yet the defendant alleged the misrepresentation were made by the claimant by third parties, Mr. Mehdi and Mr. Araj in claimant's skeleton, paragraph 72. Neither is a party to the indemnity agreement. The defendant implicitly suggests that Mr. Dazi acted as a claimant agent. However, establishing agency under UAE law, particularly apparent authority, require a specific condition to be met. First, as outlined by the Federal Supreme Court case number 180 of 1988, where the court cited the esteemed Professor Abdulrazak Al-Sanahuri in Bundle I-19. The principal must have acted in a manner creating reasonable impression of authority in the third party, I mean defendant here, who must also acted in a good faith and took all ordinary precaution to verify the authority. I repeat that he should have taken all ordinary precautionary to verify the claimed authority of Mehdi Desi and Araj, which he could have done it easily, being partner in the company. In this case, the evidence points quite the other way. As I understand from the discussion from the cross-examination, Mr. Desi was engaged to assist all UPO in the restructuring. So he was not assisting the claimant, he was assisting everybody. Not exclusively with the claimant. Claimant skeleton, paragraph 84. I further understand, my lord, that the defendant himself acknowledged Mr. Desi connection to the UPO. So he was working for everybody. He could have told him and asked and act in a reasonable manner by asking him about his authority. And the evidence suggests that Mr. Abadi may have paid Mr. Desi, which is not the claimant. In this circumstance, Your Honor, it could not have been reasonable for defendant to simply assume that Desi spoke with the binding authority of the claimant on these alleged crucial matters. It's a very, very difficult for me to understand. The defendant also did not take any apparent step to verify the alleged authority, as I stated, directly with the claimant, who was his business partner. A failure to take ordinary precaution, highlighted by Professor Sanahuri, claimant skeleton paragraph 86, without establishing agency that alleged representation by Mr. Desi cannot attribute to claimant, and the Article 185 defense fails on this ground as well. Furthermore, the defendant, my lord, dependent on Article 190, deceit by third party does not assist the defendant. I spoke about it. The defendant claim would still fail under Article 190 in Bundle I-2. Article 190 specifically addresses deceit committed by someone other than contracting party. It allows the victim, the defendant in this case, to rescind the contract only if he established the other contracting party, the claimant, Mr. ALMHEIRI, had a knowledge of a third party deceit. So basically, he should establish that Mr. ALMHEIRI knew about the deceit of the third party. So burden is squarely on defendant to prove the claimant knowledge. So he has to prove that Mr. ALMHEIRI knew about it. As my late friend, Mr. Harrisburg, has demonstrated through factual evidence matrix, and I have submitted regarding failure to prove deceit in the first place, the defendant had offered no credible evidence whatsoever that the claimant knew actually about alleged deceit committed upon defendant. Therefore, my lord, the misrepresentation defense failed not only because no deceit by contracting party or by their proven agent has been established, but also because a specific requirement under Article 190 of third party deceit, namely claimant knowledge, clear knowledge about, has not been as well met. The fourth element, the alleged representation themselves, are detailed in paragraph 87 to 93 of the claimant skeleton argument, are fundamentally unclear, contradictory, and lack basic particular required to ground a serious allegation, which the claimant has denied. Neither defense nor the defendant witness statement provide adequate detail of word used. Which word used by him? Because the Article 185 required the word used to deceive him. When was that used? How these alleged representations were supposedly made, or on what specific context? The defendant account shifts significantly, particularly regarding who would provide indemnity and the nature of timing.
Dr. Hussain, On this aspect, I've had Mr. Bohr make his submissions, and I think you're covering the same ground.
Okay.
I'm interested. I think I'm interested from you any points of UAE law, which Mr. Bohr hasn't dealt with, but we haven't.
I would, about the article relating the question you asked me, my lord, about SALEM. Article 463 applies to the right between joint debitor who share single unified obligation. Here, the defendant and Mr. Araj entered into separate indemnity agreement with the claimant. They did not sign single joint indemnity agreement. As established by esteemed Professor Al-Sanahuri, who was quoted previously by the Supreme Court of UAE in Bundle I-19, when multiple guarantor or indemnitor in this context secure the same underlying risk through separate successive contract, they are not considered jointly liable. Instead, each is a liable in SALEM, meaning each is individual responsible to the creditor for the whole amount promised under their specific contract. The creditor dealing with one under this separate contract do not automatically impact the obligation of the other under their distinct contract. Article 453, considering discharge by a substitute settlement with one joint debitor, is inapplicable because, as established, the defendant, Mr. Al-Araj, are not joint debitor under a single agreement. So the requirement for Article 463 is that one single agreement they sign. However, in our scenario, each independent one has the individual agreements, which is different.
I understand that point, yeah.
Yeah, and another point regarding mistake or ghalat, which was raised, I think, by my late colleague, Mr. D. Wolf, actually. In a very brief, my lord, it's related to but distinct defense of mistake or ghalat under Article 194 and 195 of the Civil Code. It's in bundle I-4 and I-5, which the defendant raised the alternative defendant skeleton paragraph 31. With respect to your honor, the defense is even less sustainable than the misrepresentation claim even. First, as established by case law such as Appeal 1469 of 2024 I-6, a mistake rendering contract void under the Article 194 must relate to the fundamental essence of the contract, a condition for its formation, or the subject matter of itself. If we apply this judgment on our case in hand, the indemnity, he knows the subject matter of indemnity. He knows that he's indemnifying him if he has a loss, and he knows the amount of the loan in play. A mistake allowing rescission under Article 195 must relate to significant, desirable quality of identity. For example, I am going to buy, for example, subject matter, for example, car, I bought computer. This is a different identity. And these alleged misunderstanding about collateral matters simply do not meet the high legal threshold, because otherwise, if the mistake, it will be claimed frequently will be by the court, but the court or the law put high threshold. It should be something very essential in the contract. Second, the entire agreement clause, which I addressed earlier, equally applies here. The defendant agreed he was relying only in the express term of indemnity agreement, negating reliance on any mistake or assumption. Third, as deceded by the third party, there is absolutely no basis attribute knowledge for alleged mistake to the claimant, which would generally be required for mistake to be actionable against the claimant. In short, my lord, the mistake defense failed both factually, as the alleged mistake are unsustainable, and legally, as they do not meet the specific requirement of Article 195 and 196. If that were not enough, they are barred by the contract on terms, actually.
Yes, thank you.
That, my lord, I think this is my...
Yeah, that was very helpful. Thank you, Dr. Hussain.
I think, my lord, one last two minutes, I need to address one of the questions raised by you, actually, raised regarding distinction between a statement of fact and promises under UAE in context of misrepresentation.
Yes.
If you would like. The
Just
claim
very quickly, if you could.
Yeah, actually, very quickly, actually. The claimant maintained that UAE law draw distinction, actionable misrepresentation under Article 185 of the Civil Code concerning false statement of present or past fact involving tricky and decisive induced consent. We submit the defendant allegation concerning alleged promises about a future event do not meet the legal threshold, which I explained, of misrepresentation under Article 185, which I tried to explain even in Arabic, for the reason previously outlined, including nature of a statement, the entire agreement clause, and the lack of decisive indictment. And thank you very much, my lord.
Well, thank you very much, Dr. Hussain. I think that now brings us to the close of proceedings, apart from the fact you expect a judgment from me at some stage. And can I thank you all very much for your helpful submissions, and equally, well, not equally, but also for your agreement on timing and sticking to your agreement on timing, the latter being particularly rare. So thank you both very much. Thank you all very much for your help, and I'll get you a judgment as soon as I reasonably can, but it won't be by tomorrow. It'll take a bit of time. Thank you.
Thank you, my lord, and thank you for keeping us on track.
Thank you, my lord.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you very much.